KP Pathak sir is appearing in these matters. So Lordship, this may be, I have filed Lordship, this may be taken up along with that Lordship.
Okay.
Obviously.
Your Lordship, may I mention item number 18?
Item number?
18.
Pass over this matter, madam.
You are for petitioner.
Yes,
Your name, please.
A Khalek.
A Khalik, Learned Counsel, appearing for Mr. L.R. Mazumdar, Learned Counsel for the petitioners. The case is passed on the prayer of censure. The case is passed over for the day. It is submitted that consent has been taken from the Learned Counsel. Have you informed the other side?
I know no.
Then no. Next.
May I please, Your Lordship? I beg to mention item number 16. I am for a petition with due consent of the other side. In this case, my Lord, respondent number 2 has filed an affidavit yesterday, Lordship. We have my Lord received, my Lord, which is not on record, Lordship. We need some time to go through it, Lordship. At least 1 week time may be given, Lordship.
On the prayer of Mr. D. Gugoi, Learned Counsel for the petitioners, release the case after a week on a date to be fixed by the office.
Hi, Your Lordship.
Special prayer for listing a writ petition, old matter, Your Lordship. It has been last posted on 3rd June of 2022, Your Lordship. And thereafter,
Next.
I'm so obliged.
My Lords, may I mention item number 18, my Lords?
18.
Yes, my Lords. I'm appearing for the petitioner in this matter, my Lords. I'm seeking an...
What is your prayer?
I'm appearing for the petitioner, my Lords. I'm seeking an adjournment for today as main counsel's father expired, so he'll not be able to appear today, my Lords.
Who is the main counsel? Your name, you are Anupadhyay.
No, I'm Akansha Singh. I'm proxy counsel of Mr. Pankaj Mehta.
What is your name?
Akansha Singh. Akansha Singh. Akansha.
MSAC. Learned Counsel representing Ms. Anupadhyay. Learned Counsel for the petition has submitted that there is bereavement in the family of MS Upadhyay, and as such,
My Lords, not in the family of MS Upadhyay, Mr. Pankaj Mehta. In the family of Mr. Pankaj Mehta.
Who is Pankaj Mehta?
He is the main counsel, my Lords. And
His name is
Upadhyay,
not there.
my Lords, he is the arguing counsel also. He was arguing for the last for every hearing.
Is he a senior counsel?
No, my Lords, he is arguing in this matter. Miss Upadhyay is a
No, we do not know.
she's
His
a
name is not
registered.
appearing. Due to representing Ms. Anupadhyay has prayed for an adjournment of the case. By what time?
Any date, my Lords, any date.
By 2 weeks. Mr. G. Goswami, Learned Standing Counsel, NF Railway, who is in attendance, has submitted that he has no objection to a said prayer. The prayer law leaves the case after 2 weeks on a date to be fixed by the office.
Date may be given, madam. Whether a date may be.
No, 2021.
Much obliged, my Lords.
Item number 1 for motion.
A mention memo to that effect has been circulated yesterday.
May I please, Your Lordship?
Yes.
In this case, my lord, under RTI Act, I applied, and thereafter some fees has also been taken.
Mr.
20,000.
Counsel, there is a fees fixed, which you have paid partly.
My lord,
Now, how your right has accrued to file this writ petition? You have made part payment.
my lord, I am a resident within the jurisdiction of.
No,
the state.
question is that under the RTI Act, you are supposed to deposit certain fees
Yes, my lord,
fixed by the PIO, right?
my lord,
Rightly or wrongly, they have fixed a amount, and you have paid 20,000 out of it.
my lord.
Now, what right do you have accrued?
My
You
lord,
have paid the fees partly.
that amount is not the fees, my lord.
What?
For preparation of the information.
Cost?
Yes, my lord.
And cost you are not depositing. You want to purchase a flat. 30 lakh. You pay 20 lakh. Then you come to the court. Give me the flat.
My lord,
What right?
fact is that I am ready to pay the remaining amount
You
also.
deposit. Then if they do not act upon it, then you come. And there are other authorities. Why writ petition?
I have applied before the state authority, my lord. Kindly come to the page 29, my lord.
See, Mr. Counsel, you've not deposited the cost. Fact of the matter is that they have determined an amount as cost for supplying the information.
But
And you have paid it partly.
but their plea is not that for the non-payment of the amount they have not supplied the.
No, what right? Then cost, let us see. What is the provision for cost? What is the provision for cost? Please tell me.
You take section 7. Subsection 3.
There is rule, Assam right to information, the right to information rules 2012 also. Rule 4. Then subsection 3, section 7. When you are not fulfilling this statutory provision, how you have the right?
May I suggest one thing, my lord? Let the matter be closed with a direction to pay the remaining portion and they supply me the copy.
But I appear for the commission, so I'm only the implementing authority. State responding. But however, I take one point. The information, the payment which was sought from the applicant was sought after 30 days. Section 7(1) says, section 7 subsection 6 says, if the payment is sought after the prescribed period in subsection 1, information should be provided.
There are other fundamental which whether this society
That
is a public authority.
But once they have say asking the money for giving the information, they have.
No, who are the authority?
What I'm suggesting, Lordship, is that if information is not provided 30 days, information ought to be provided free of cost, as per section 7, subsection 6, Lord.
Subsection?
6 of section 7, Lordship. But it is not very clear as in when he has filed, because first appeal itself is within 1
No,
month.
when his application was
Application was
submitted.
page 22, Lordship, is the application. Date is 12/6/2023.
Hmm. No, RTI application?
12/6, Lordship. That is the fees received.
No, no.
14
Firstly,
to my
tell
lord.
me,
14 to my lord. Page 17 may kindly be seen.
okay, received. Then it was forwarded. Then it was forwarded on 28/2.
Yes, my lord.
Appeal is page 24, first appeal, right?
No,
19/1.
28/2. Then what happened? Appeal,
Page 24 is the notice under
page?
24. It's notice under section
Section for
91. That is
following
the first
person to
appeal.
appear before so and so in office chamber of the honorable hearing the appeal petition. Submitted. Okay. This is on,
27/6.
yes. Appellant is present.
The payment was sought for in 22/8/2020. That is the amount.
18/7,
26 is the page, Lordship, for the money received.
page 25.
Yes.
Ensure that the required information will be provided. Page 25,
Yes, Lordship. That is the order of the first appellate authority.
within 5th August,
Lordship.
within 5th August,
Yes, my
Yes, Lordship. Then he
2025.
the order was after 30 days was over for the prescribed period.
Huh?
The prescribed period for giving the information as per the act is 30 days. Once that is lapsed, information ought to be provided.
No,
to
come
us.
to page 25.
Yes, Lordship. That is the first appellate authority.
Oh, then read the order.
Report in provide within 5th August 2020 to the applicant. Applicant also agreed.
Deputy Director ensured that the
That's correct.
required information will be provided within 5th August to the applicant. Applicant also agreed. Okay, thereafter,
That amount was money received of RTI under section 6(3).
now who is Deputy Director, in what capacity? Deputy Director,
Lordship is reading from page
25,
He is the first appellate authority, Lordship. Nobojyoti also ACS.
he is okay, but Deputy Director? Who is he?
Food and Civil Supplies Deputy Director, FCS.
Huh?
That will be
In what capacity?
he will be the PIO, Lordship. He is the information because his name appears in the first appeal. One is the applicant, other one is the PIO, the Public Information Officer.
See, what is the authority from which information was sought for? It is a cooperative society,
Yes, Lord.
is it not?
What I'm not,
And in what capacity? That is what I am asking. Everything is proceeding perhaps wrongly.
maybe, Lord. But
Everything
also-
is proceeding perhaps wrongly. That is why I am asking
See,
you.
I'm representing the authority.
Then why you are not acting under section 18 then?
They have not filed a complaint before us.
They have
only
filed.
Only filed an appeal, Lord. And it was not in format, and that's why we returned on 15 December 2023 itself, Lord.
Where is that?
This page 31 in vernacular, Lordship. Mananiya Mukhya Tathya Ayog, Bifaya Mohoday Homibeku Ahom Panjabari Guwahati. That is a appeal without any annexer. So we returned it to him, asking him to file it properly.
Yes, Mr. Counsel. Whether the second appeal has been returned to you,
That was returned on 15th of December itself, within 3 days.
then why you have suppressed this fact?
Return the seal. Return the seal. My lord, I have to take instruction. my lord.
Then that was in 15 December 2024.
Because at the time of.
Your
rejection-
second appeal has been returned by the commission. Then have you mentioned anything in this writ petition?
Regarding that, I have to take instruction. my lord.
Then-
That is not informed.
This appears to
Let
be
me come.
suppression of fact.
Yes, my lord, let me take instruction.
That will invite also cost.
My lord.
Instead of paying cost, you pay to cost for the larger public interest. Okay. Mr.
Yes, Alim.
Halim, learned counsel, what Mr. Salim, learned counsel for the petitioner. And you, Mr. Das,
D Decca.
D Decca, learned counsel, representing the respondent number
One note.
1, full stop. And for 12 people. Also heard Mr. N. Goswami, learned counsel. Do you have a copy of the return?
Lordship, I do not have, I have a soft copy. I can provide it.
You send it to the postmaster. Right now, if it is a case of suppression
Yes,
of fact, we'll deal with it. Learned junior government advocate, Assam, for the respondent number 2 and 3. Mr. Decca is 1.
One.
Full stop. It is submitted by Mr. Decca, learned counsel for the respondent number 2. That the petitioner had approached the Assam State Information Commission by preferring an appeal under section 19 of the Right to Information Act on 11/12/2023. And he has been informed, it is informed to him that the said appeal has been returned on 15/12/2023 as the appeal was not properly filed. Full stop. Mr. Alim, full stop. As there is no pleading to the effect that the appeal preferred before the Assam State Information Commission has been returned on 15/12/2023 in the writ petition, Mr. Alim, counsel for the petitioner, has paid for some accommodation. Post of accepting the prayer list, the prayer is accepted.
So the third paragraph. Yes, sir.
Mr. Decca, learned counsel for the respondent number 1 has placed a copy of the said order dated 15/12/2023. Full stop. As there is no pleading in the writ petition as regards the return of the appeal by the Assam Information Commission, it privacy appears that the petitioner has preferred the writ petition, its suppression of fact. At this stage, Mr. Alim, learned counsel for the petitioner, has paid for some accommodation, has paid for release the case on Wednesday.
Tabla, ma'am.
Item number 2.
Yes, Mr. Decca.
May I please, your lordship? The matter may be passable for time being.
This is the case, I think, where he is involved. Register, Assam Information Commission, go through it.
Yes, sir.
We'll try to dispose of.
Item number 3.
item 3 that panchayat matter minor.
Yes.
My learned friends, item number 21, 20 supply, out of the same minor, same constituency, same case minor.
Okay.
Similar. So I think your lordship already had that matter. I think he will start first minor, then
Sometime, yes.
that will be better.
Lordship, in the item number 21, Your Lordship, the petitioner has finally replied affidavit yesterday. Also, we have received the copy yesterday. So, Your Lordship, we need some more time for appraisal of the record.
No, I will not refer to the reply. I will not refer to the reply. My reply. More rely no.
And Your Lordship, the learned advocate general have also some difficulties today.
Something.
He has
Notification
difficulty.
is likely to be issued.
Hmm?
Panchayat notification is likely to be there. He may be assured that I will not even refer to one page of the reply.
Lordship, the couple of this time is required.
Huh?
If it, so far as the learned advocate general is leading this case, Your Lordship,
Yes.
he has some personal difficulties today.
But if the meantime,
If it is recorded that notification will not be issued, then of course.
Such instruction is not with us. Your Lordship.
That instruction, then
Such instructions that they are going to issue such notice, such instruction is not with us.
hmm,
Such instruction is not.
when? Thursday?
Lordship, on Thursday, he has some problem.
See, this should be early.
On Monday, Your Lordship.
Monday I have problems. I have some personal problems of some other. I will complete my part of the argument so that my learned senior colleague is also there. He can take care of it. Yeah, on the more.
Thursday, he will be available.
On Thursday, some other meters are fixed. Your Lordship.
And then Mr. Pathak can argue on Thursday.
My lord, at least
Then he can complete.
may I have an indulgence of your lordship? Since I have the privilege of having Mr. Chaudhary also, I have some other difficulties next few days because of.
Oh, yes, yes.
Let me complete my part. I assure him if he wants to argue today, I will not even refer to a single page in my reply. That much fairness I have. And later on, he may take it. Have
Your Lordship, the
Adi to education nohoy. More argument kini ko uthi jabote.
yes, then Your Lordship, the our part will be maybe hard later on. Your Lordship, some other day.
So otherwise, what is your tentative date?
Tentative there on Tuesday, Your Lordship, next.
Okay. Then,
I will have the indulgence.
yes,
Apun
then
kisi ko,
they can proceed today.
because I have.
Their part, only their part. Our parts on Tuesday, Your Lordship, next.
Okay.
Only my request is that Panchayat election notification is not issued in the meantime.
No, we cannot also do something.
Sure, sir, that this should come from there.
Because last two occasions, the time has been brought for. I have no other problem, well, only I am arguing on that understanding that let us understand what is the law about.
Yes.
For the last two occasions, Your Lordship, we have taken for filing our counter. And they have also taken time for filing their counter.
No, that has been agreed upon. Agreed upon. That was agreed upon as suggested by the senior counsel from the petitioner and learned advocate general. That
It is
today we'll proceed.
I request my brother colleague that it is a rare opportunity coming to be here in this particular hearing.
Yes.
The choice is his.
Yes.
How item number? 21.
Oh, fine, let him do it. I will,
Yes.
my lord, I will address your lordship on the first proposition is that what is the legal, what is the legal implication of a notification being gazetted? That is the first, I will address your lordship on that implication first. Because here is a notification first and then it was gazetted. So before going to what was the violation of section, I will come in the second limb of my argument.
Mr. Pathak, better use harp on the second aspect. Violation of statutory provision.
Violation of
Section 5.
my lord. I'll,
No.
it will be my pleasure.
At least a glimpse.
My lord, before I take your lordship to the sections, I'll sum up how this particular act, so far the delimitation is concerned, has been framed. Now, this act has undergone an amendment also very recently.
Yes.
Now, first, what is the before I take you to the lordship section wise. A Panchayat Act envisages a section called Section 3A.
Yes.
Section 3A relates to this Constitution of District Delimitation Commission.
Okay.
With 3 members
Hmm.
and the district deputy commissioner, nowadays called district commissioner, as the presiding officer. Now, there is another section. The section can be now trifurcated. Section 5. Section 5, if I can take your lordship to section 5, I will go little slowly. There is it can be trifurcated. First part is says, I'm reading first part, my lord. I'll take your lordship to the section later. First part relates to the power of the state government to declare any area, let us call it any area, it may be territory, it may be this, as a Gaon Panchayat. What is important is the last few words of the main section. As per the category within which the district falls. That means the first, after trifurcation of the section, first
Yes.
part says about the power of the state government.
Yes.
Power of the state government is as per the category. That means it presupposes there has to be a categorization first. Now, proviso. Next, proviso has again 2 parts. Actually, these 2 parts, my lord, I am dissecting the section. Proviso says power of the state government to declare these 3 categories. First part says about declaration of a Gaon Panchayat as per category, has a lordship.
Yes.
Second part, proviso, while dissecting, I find, is the power of the state government to declare 3 categories, has a lordship. Can I read it? Proviso says, provided that means this subsection 1, how it has to be carried forward. Provided that the state government shall declare 3 categories of district based on population density or, your lordship will population density or any other relevant factor as follows. Has your lordship?
Yes.
So the proviso is the duty of the state government to declare categorization. That declaration has to be either on the basis of population density or on the basis of any other factors. Now, District Delimitation Commission, after this declaration is made, now after this categorization, the district delimitation, what it is expected to say that category A, B, C, these are done through the declaration. Has a lordship got? So category A will have a population, all panchayats will have a population of this to this. Category B, this 8,500 to 11,000 so and so. And category C, May I here pause here for a moment, my lord? First, the problem is that because of the drafting thing, first is the power. Power to declare a area as a Gao Panchayat on the basis of categorization. This is the first part. Now, what is categorization? The next is the government's duty to declare the categorization. That declaration notification will be based either on population density or any other fact. Once this categorization is done, Delimitation Commission has not much duty to left behind. Moment that this deputy commissioner knows there's my district in this category, he has to now find out areas in such a way that every panchayat is 8,500 to this. He does not have to go by population density or this. He has to go by the declaration of the government that so-and-so district, Nagaon district or Lakhimpur district in this category. So the section 3A, your lordship will kindly see. Section 3A. District Delimitation Commission is comprised of deputy commissioner, nowadays most probably district commissioner, chief executive officer. They do not have much to do with calculating the population density. They have to know only the categorization. This is my understanding of the law. Now, may I pose a question to myself here?
So according to you, that declaration regarding categorization
Of the district,
should be at the first.
of the district should be first. And that categorization will be on the basis of population or any other.
Other relevant factors.
Then that categorization, when it is categorized into ABC, that is also specified how many population will be there. Now, may I pose a question to here myself, my lord? Why this act is referring to population? This has a connection to Article 243C. There it relates to the delimitation of panchayats. There it speaks about population, not any other factor. I am taking your lordship to the constitution now. Because there must be some rationale behind it. Why suddenly this population has come? Your lordship will kindly see 243C.
In the same ratio,
It is the same. Population is the main criteria.
as far as possible.
My lord, I am obliged. So as far as possible. So population is the guiding factor. Then again,
How this proviso is worked out?
my lord,
How this proviso, tell me an empirical or a mathematical examining, arithmetic examining.
my lord, officially they
Example.
say
No, no.
it is
I'm
mathematical,
not
but actually
understand.
it should be empirical.
Huh?
It is not possible otherwise because they are
No, the same, even a hypothetical example.
my lord.
I have not understood it. I have read and read this proviso. I have not understood it
My lord.
in the arithmetic way.
I have also not understood, my lord.
So-
I tried to be very honest. I tried my
I have
level best in the
read
arithmetic.
it many times,
Many times.
but I could not understand how it is to be arithmetically worked out. You had a population figure.
The proportion.
Say,
How
Mr.
to
Pathak, I'll just put it across to you. Say, provide the ratio between the population of the territorial area of a panchayat at any level. Any level means Anshalik, Zilla and Panchayat. Gaon.
any level.
So, ratio between the population of a territorial area of a panchayat at Gaon Panchayat level. Take it as 1 lakh. Tell me how it is to be worked out.
My lord, here is the catch point.
I do
Suppose
not.
Today
I
I
am
appear
not.
for the advocate general.
Huh?
Today, suppose I am appearing for the advocate general. The contra argument against me would have been that look, who is ultimately determining the ratio? It is the state government.
Yes.
Now, here, which area, territory I will take, it's my choice. I am arguing for the advocate general. That's why what has fallen from your lordship, it is a Pandora's box.
I'm not understood
I have,
actually.
my lord, to be very honest, with this few years of practice at the bar.
No,
I also
I
have
have
not
lesser
understood.
experience than you.
No, no,
So I have not understood
my lord,
this proviso.
that's why I did not want to dig into it. I am just understanding section 5 as it stands. Because somehow because I have to be fair to the honorable court. Because I was actually, that was what was troubling me. But again, after working for a few minutes, I found better to confine myself to section 5 because
Because it requires that same throughout the state.
my lord, that is not impossible. That is not possible.
That is not possible,
That is
but
not
as far
possible.
as practicable.
As far as practical, but
Practicable. It is
also not
practical.
it is also not practical.
Not possible also,
It is-
practical.
It is not practicable, also not possible.
So it is a provision based on practicality.
Constitution, sometimes the makers, with all due regards to them, this is inserted chapter 9. The real ground reality is sometimes not realized what happens exactly. So better, my lord,
If you do not understand this proviso, because if it is relatable to that section 5 proviso.
in fact, I've thought of this question calling from your lordship. I will say it is not relatable. Why? It says the government, state government has the power to make its own law for delimitation. So
But that cannot violate constitutional provision.
provided how it is to be interpreted.
To
Violation will, in what I do not know how to interpret.
be fair, neither your writ petition nor your reply affidavit state has address on this issue.
My lord, because
I might be clear.
I should not better address a point which I myself, because in the early days of my life, I was taught, don't ask a question in cross-examination, answer of which you do not yourself.
Yes.
So
your petition is based on basically proviso
Section
to
5.
section 5.
section 5. Since I do not know the answer myself, better not.
I also do not know the answer how it is to be worked out.
With my limited, very few years of practice.
But I think there was a delimitation exercise for the state LAC.
Yes, your lordship has issued notice. I will have notice on
State LAC.
state LAC.
So I think what was the population base they had taken?
That was population. That was population.
Yes. What
Because
was the base?
Constitution provide.
Yes. What is the basis?
2001.
What is the basis? Which population?
2001 census.
2001.
Because Constitution provides that henceforth, next census population will be taken.
2026.
2026 of population.
Okay. Then as a result, LAC areas are marked already.
Marked.
And what is the provision for Jila Parishad?
That here.
Because
Panchayat.
you are taking a bottom-up approach.
Bottom-up approach because.
But let us take a top-down approach.
The top-down will be hypothetical approach.
Because one LAC, what is the provision for Jila Parishad? A Panchayat.
Section 84. 64. Because why I have chosen from the bottom-up position, the Jila Parishad Constitution issue is yet to come. It's like a pyramid, my lord. It's a pyramid system.
Yes, pyramid system.
It's a pyramid system.
So for every district, there shall be a Jila Parishad.
So like it goes down. So if we
And
cannot.
our
catch
entire
it now at
district,
the Panchayat level,
excluding such portion of district as are included in a municipality
my lord.
or under the authority of town committee cantonment. So one district,
My lord,
excluding municipal area,
like this,
is Jila Parishad. Then what is Anchalik Parishad?
that's the territorial area within the Jila.
Let us see the provision.
Town Anchalik.
30?
32.
No, 31. For each development block, there shall be an Anchalik Panchayat, excluding the block as included.
So now the next come is the development block. Absolutely at the bottom is the Panchayat. So
Yes, yes.
without the panchayats, neither development block will come, nor Jila Parishad will come, nor anything will come.
Now, which one will come first?
Panchayat. That is the bottom line.
Because
They have to be
at
now.
the same time, it is district.
Yes. they
Jila
have to-
Parishad.
My lord.
Jila Parishad, what is the constituency? Any provision?
Yes, my lord. Because unless the bottom is there, in the pyramid, the top cannot be there.
Now, let us see.
We'll do this.
65.
Establish 65, my 64, 65.
Hmm.
Constitution is the 65.
The Jila Parishad shall consider the territorial constituencies. May by notification determine the territorial constituency is keeping in view the overall population at a rate of 1 member for a population. So every LSC will have 4 constituency. District is excluding municipality is Jila Parishad.
Yes. My lord.
Excluding
Excluding
municipality is Jila Parishad.
My lord.
Then Jila Parishad will have each and each development block
Development block.
will have, oh sorry, each LSC will have
4.
4 territorial constituencies. Does it have any relation with Anchalik Panchayat?
Anchalik Panchayats, my lord.
Each LSC will have 4 territorial constituencies.
My lord.
Okay,
That's section
LSC
31.
is 4 constituency. 30,000. There is also fixed. This is so interrelated.
Interrelated. Your lordship will look at section 31.
We'll see that. But section C 60, 60 or what? 60, 4 proviso. 64 proviso, first proviso. 30,000,
My lord.
4 constituency. Oh, sorry. Territorial constituency in view of the overall population at a rate of 1. 1 member for a population of not less than 30. And each territorial institution shall elect 1 member. Second proviso.
My lord.
Each LSC will have 4 territorial constituencies. So, $30,000. Because the situation in one Gaon Panchayat cannot overlap into another
No.
LSC.
It cannot be, it may be contiguous, but it's overlooking.
You cannot. So there is some relation also.
Relation, again, we go back to that after the delimitation, district delimitation commission's actually duty is very limited. Once the categorization is done, he or the committee has to know which is my district, which category is my district. So when he does the adjustment of the boundaries, he has to do the adjustment in such a way that this particular limit is maintained. Nothing more. That I don't have to calculate what is my density of panchayats.
Okay, if it is a condition precedent that a declaration should be made categorizing the district.
My lord.
Yes, Mr. Additional Advocate General. Do you have any declaration regarding categorization of the district?
So their instruction is not.
Please find out.
We'll have to take instruction.
No. Please find out during the course of the argument.
Yes, sir.
If it is there, Mr. Pathak's submission might fall flat.
Fall flat. It will fall flat.
Yes, sir.
Whole argument
Very simple.
might be I will be out of the court if,
Yes.
if this answer comes.
Yes. Since it is declared There
All-
must be.
First is the declaration of all the districts.
Right. So since the word is declaration,
I will not expect you.
declaration must be a public nature.
At my level, at least, I will not expect your lordship to lift the veil. Why this declaration? Why not that declaration?
No, declaration means, I think,
Some notification has
some
to be-
kind of
notification has to be
in the public domain.
public domain.
That
Because
is what. If declaration is there
My lord.
and all these writ petitions are filed without adverting to that declaration,
because
then it will be,
of course,
see,
my job will be more tough.
yes,
If the declaration is there,
yes.
then next job, my duty will be if the
Because
declaration,
declaration is also laced with a condition, any other relevant.
now let me assume against me, that declaration is either pedantity or any other
Any other.
factors,
But question is,
declaration is there.
where is
My-
the declaration?
No, but suppose this is there. I'm arguing, I always think against.
No, why should we
No, but my lord,
broaden the argument if something is not there?
my second link of the argument will be, if the declaration is there, then whether the delimitation commission is maintaining that,
Yes, that will be
that
the
is the
question.
next argument. But why I am saying so, the much of my time I have spent, what was troubling my mind, that unlike the RP Act and the Delimitation Act and the Panchayat Act, there is a difference. Representation of People Act and the Delimitation Act, it has a two stages prior. That once the delimitation order is issued, it will be laid before the House of the Parliament. And if it is state legislature, it has to be laid. Then a notification will be issued, most probably section 10 of the Delimitation Act, which has to be gazetted. This section is not there in the Panchayat Act. Only a notification. Be that as it may, they have now
Hey, Delimitation Act also.
Delimitation Act, my lord, section 10.
Delimitation Act. আছে না?
এখন extra copy আছে?
সৰু একটা হ'ব।
ইমান মোটা।
একদম সৰু।
The privilege, my lord, that I'm still trying to
No.
learn something out of.
No, I am learning. I'm not very accustomed to election laws, delimitation.
Section 10,
If I remember correctly, 10, I think
section 10, my lord, subsection 2.
10. Now, there is a provision that shall not be, have the force of law.
Now,
This is the-
gazetted
this
and
is
have
the-
the force of law.
That is a distinction.
This Panchayat Act neither speaks of being gazetted and the force of law. That takes me to another link, my lord. This particular submission,
Hmm. One second, just a minute. Yes.
now, this takes me to another stage. This Delimitation Act provision, more or less similar, my lord, excepting the section 8 in the RP Act,
RP Act 50.
representation of people. The requirement of gazetting. Section 8 also requires official gazette. As your lordship. Last official gazette of the election commission. Section 8, my lord. Constitution of Delimitation. As your lordship. The first subsection 1, the last few sentences.
Consolidation.
Consolidation, and next is section 9.
No, I think section 8A,
8A, ma'am. I'm sorry, I stand corrected, ma'am. Yes, ma'am.
it
Your
should be 8A.
Yes, ma'am.
8 is not related to Assam.
My next is related. Yes. Section 9, my lord, the RPI. Power of Election Commission. As your lordship.
So 8A has been implemented recently. A presidential order has been rescinded. Assembly constituencies, parliamentary constituencies, delimitation exercise was carried out.
Carried.
And election was also held.
Election held, but the challenge is on.
Challenge is on, but
Election is held.
election
Because the
is,
notification came in the meantime.
yes.
Now,
So election is held, so 8A is done.
8A
Assembly
is
constituencies are
for the LSEs.
LSEs.
What I exactly wanted to point out, that in the matter of delimitation, there is a difference between the Panchayat Act and the RP Act and this, where is the presumption of law. Now, I argue against myself now, that the law did not require notification. Panchayat Act. I have now gazetted it. This gives the immunity. I am arguing against myself. That makes me to understand to the Black's Law Dictionary definition of notification and gazette. Notification is a formal announcement of a legally admissible fact, an action or an intent that I want to do this, to notify people who are likely to be affected thereby. Gazette has been defined as a legal journal or a legal newspaper of the crown, now the state, it has been bracketed as state, intimating the crown's actions or intended actions. What happened? That time, I have seen the history, that time the crown of England, he said with his knights and all, took a decision within the palace. And first decision was, first notification, if a lordship goes into it, that particular street will not be any longer a two-way traffic. The king decided. So and the knights decided. That has to be made known to the people. So it was gazetted in the British Gazette. Now all actions, whatever is the crown, are gazetted. That's why it is called newspaper or the legal journal of the crown. And that's why if we look at section 81 of the Indian Evidence Act 1872, that time we were under British, they extended it, section 81, that presumption of the contents of a gazette notification. Section 81 of the Evidence Act does not even whisper that this presumption makes it immune from the judicial review. After all, it is a common British, they have developed the law. They are saying that it is contents of, because it is gazetted. But it has not said, section 81 of the Evidence Act 1872, that it is immune from the judicial review. This particular limb of argument, my lord, if your lordship gives me half-minute time, I had a peculiar experience in my young days as a lawyer. Here is a warrant of the president appointing a particular Mr. X as a judge of the Guwahati High Court. And that warrant of appointment of the judge was issued, followed by a notification from the secretary to the President of India. That came to be challenged in Guwahati High Court, somewhere near Durga Puja time, and had a privilege to appear in that case. This point, Honorable Justice Sangma, he says that judicial review is much higher concept because it's a Crown's order, much more than a gazetted order. Gazette is a notification. It's a Crown's order whether we can stay it or not. The stay was granted. Swearing in was stayed. And even the notification issued thereafter by the Secretary of the President of India was stayed. That was Kumar Padma Prasad case. The matter was taken up. It was taken over from Guwahati High Court to the Supreme Court and later on decided, yes. Then that order of judicial review, and later on the President of India was communicated that it is bad in law and this has to be recalled. So that was judicial review. Now coming to the present case, it is not the Crown's order, it's the Crown's of the Knights. Now question is, Gazette is much lower than the President's warrant, where the judicial review was exercised. Now, the question is, section 81 says that contents of it, that is true. That means public should know what has come out in this notification is true. Section 81 is the British Evidence Act. Now the question that I may have little watermark. Now, here it will be unfair on my part if I do not take your lordship to section 129 of the Assam Panchayat. Panchayat Act. Panchayat Act. 129
That is akin to 243O.
243O. 243O is in part 9. That has 243O has been borrowed from 329. Like this saying has been maintained. Now, what is exactly barred by law? Barred by law is notwithstanding anything contained. I'm sorry.
Yes.
I'm reading out from 129. No,
Yes.
bar to interference by courts in electoral matters. Notwithstanding anything contained in this, the validity of any law has a lordship court. The validity of any law relating to the delimitation of constituencies on the allotment of seats to such constituencies made under Article 243 of the Constitution of India shall not be called in question on any court. Now, first thing first, my lord, Here, I am not challenging the validity of any section 5 of the Panchayat Act as such. I am for the implementation of section 5 in its, and a writ petition that subserve, I repeat it, my lord, that subserve the holding of election of Panchayat cannot be outside the purview of your judicial review.
Yes.
Now, a writ petition
Yes.
with the object of subserving the holding of Panchayat election cannot be barred by section 129. Now, I argue against myself now for once. Lordship will bear with me. Section 129, the heading will Lordship will see, bar to interference in courts in electoral matters. If I argue today against myself that it is a generic in nature, so since it has some correlation with holding of election, you are barred. I'm thinking against myself. My answer to this will be election, what is barred is election moment its process starts. The steps before it, which pave the way for holding election, is not barred. This is, I have in support some apex court decision also, I will come to it, but I am just elaborating. If I argue against myself that electoral matters means all matters incidentally connected to election are also barred. Suppose I am arguing against myself for the time. From the other side, my argument will be the holding of election is one thing, and initiation of steps to hold is another thing. It will not come in electoral matters. It is an electoral matters, no doubt, but with these matters subserve the holding. That is what I wanted to place. I'm taking a lot of valuable
Yes.
time.
Yes.
Now, here, my lord, I have one last argument. The government of Assam, which is Annexure 1. Annexure 1, they are aware that section 5 should be implemented. They say they gives a direction to the District Delimitation Commission that follow section 5. Now, District Delimitation Commission SOP, minor, page 32.
Let us read Annexure A.
Annexure A, my lord. It is a standard operating procedure, orders by the governor, has your lordship. This is under challenge. This is not under challenge. We are asking for implementation. Your lordship will come to clause 10 of clause 4, clause Roman 10 of 4, clause 4.
Let us see delimitation of Gram Panchayat clause 4.
My lord. Delimitation of Gram
yeah.
Panchayat. Actually, delimitation is an aspect which has to be decided once for all by a law, not by an SOP. It is outside the purview of the government domain. But that will be another chapter one some other day. The lordship will come to
What is this clause A? ECI notification.
Election Commission of notification that is to be
Is to be
diligently
diligently referred to for source of Gram Panchayat and villages falling in an LSC.
LS.
Any idea?
Huh? He wants to say something, he knows.
As assembly and parliamentary delimitation notification is there, but
Yes.
the election commission.
Do you have that copy?
Do you have a-
Some source of Gram Panchayat. and villages falling in endless.
What I feel, my lord, your lordship will find whenever delimitation has been carried out in Assam, in Gaon Panchayats, they are referring as a connected to LSC numbers also. These LSCs must, let us be clear on.
Oh, some connection is there because one territorial constituency of Anshalik Panchayat should have one LAC should have four.
My lord. Now these LSCs
Something-
have changed now.
Huh?
These LSCs.
Oh, yes, that is, there is some
I
connection.
get your lordship.
There
Now,
is some
that's why it's
connection
probably-
because Zilla Parishad, Anshalik Panchayat has some connection with LAC areas.
My lord, definitely, because
that
they have
has
to be
been-
member of
Yes.
the Jilla Parishad,
Yes,
and Jilla Parishad at the top.
yes, and each LAC will have four territorial constituencies for Anshalik Panchayat.
My lord.
That is what the provision is.
I-
And
I-
each-
Very good.
each territorial constituency
Yes,
must consist of some Gaon Panchayat.
that's why most probably.
And that is why,
My lord, I bow my head down. Most probably in the next clause says the total numbers will not be changed. As your lordship.
the number of Gaon Panchayat in the district shall remain the same as that of the current number of Gaon Panchayat in the district after LAC delimitation.
This is,
So it has some connection.
my lord, I'm obliged. I missed these points. In fact, it's like a pyramid system.
Yes,
This
But-
pyramid system ultimately LSCs matters
yes,
because MPs have to be member,
yes.
and bottom level is the panchayats. From panchayat to this block to
Anshalik.
Anshalik to Jilla Parishad.
And this LAC delimitation has some connection with Anshalik Panchayat constitution.
Yes, that's why they said it will remain the same.
Yes,
So don't touch the total numbers.
total number.
Otherwise, it will be a big
And
chaos
the word is after LAC delimitation.
after LS. That's what. That means they say that it will be total chaos in the
Yes.
process of holding elections.
See-
Total number remains same.
Mr. Pathak, India is not Finland.
My lord, my lord,
India population is.
my lord.
So that is the word. Practicality has been there
My lord.
in Article 243 or
243 A, C and D.
C and D.
My lord.
A mammoth population.
But this
But
ma-
question is,
the unrest-
this has some connection. And let us read further.
one Gaon Panchayat shall belong to only one LSC, and in no Gaon Panchayat jurisdiction shall be shared regarding boundary, my lord.
Hmm.
This is territorial.
No, so jurisdiction shall be shared with more than one LAC.
Yes.
So
Yeah, as your lordship just now said, it's a LSC connection.
LAC connection.
LSC connection. I missed out in the morning.
Four, one LAC will have four Anshalik Panchayat constituencies.
Yes.
And within, I
Jilla-
think,
Jilla Parishad.
okay,
Jilla
okay,
Parishad. Top is the Jilla Parishad.
yes.
Then comes the. This
And
LSC,
Jilla Parishad is the district, except municipality
except municipal areas.
or
Yes.
cantonment, whatever. And each LAC
My lord.
will have four territorial constituencies for Jilla Parishad.
But they will also be member.
They
They will also be member.
Then, if each LAC will have four territorial constituencies, it has some connection with also Anshalik Panchayat.
Definitely, it will percolate down.
Percolate down.
Percolate down to the bottom.
That is why I have asked
lord,
you
so
whether
percolate
have
down.
you examined the issue from the
Right.
top-down approach instead of bottom-down approach? Because sometimes puzzle has to be solved either this way.
My lord. But now the question is, I thought of it
Yes.
in this particular, the whole thing that has been, the problem that has been created is here, my hands are tight. because the government has directed the District Delimitation Commission go strictly by the section 5. Your lordship will look at that.
Yes, yes, I'm going, but
My-
then let us read further.
My lord.
If a Gaon Panchayat of LS is not shared among the more than one election and preferring houses, one will be retained. Not shared.
Even more stringent provision in 7.
Gaon Panchayat is to be formed without violating. But is Roman 6?
If a new Gram Panchayat is to be formed without violating the criteria 4.2.
4.2, let me see, 4.2.
4.2. The number of Gram Panchayats in the district shall remain same.
4.2.
The
4.2
number
means,
Four-
4.2 above.
above. The number of Gram Panchayat in the district shall remain same.
Without violating population, nature boundary category district shall be considered. Village shall not be primary violated if a Gram Panchayat is divided into two districts. The Gram shall be considered in a district having the Gram Panchayat headquarters. Delimitation of Gram Panchayat. Now, have they addressed on in their counter affidavit about Roman 10?
Roman 10, they have not addressed.
Huh?
They said we have asked the district delimitation.
Because that is your case, primary
No,
case.
but their stand is, I can at least refer to their affidavit.
Hmm.
They say that we have already directed the District Delimitation Commission to follow section 5. And may I have an indulgence further?
Yes, 1 minute.
Take your affidavit. Let your affidavit be.
C5 Roman 2.
5 Roman 2, my lord. It is a pre-exercise, my lord. After this Roman 2 is exercised, then most probably this 4.2, if a new 4.6 will apply of the SOP. Okay, affidavit.
No, but C is 6 to 6 Roman 1.
My lord is reading out from 6 Constitution of Benami. The Gaon Panchayat shall
This
be.
has been amended or what? 65.
It has been.
65.
It has been amended, madam.
Huh?
It has been amended.
65.
Oh, the figures have been deleted.
No, 65 1 1 1. Mr. Pathak, see this whether it is correct in view of section 65 1 1 of the Assam Panchayat Act 1994, page 33, delimitation of Zila Parishad.
Page 33 of
Petitioner repetition.
writ petition.
SOP
SOP. Page 35.
33.
33, man. Yes, ma'am.
Delimitation of Zila Parishad. In view of section 65 1 Roman 1 of the Assam Panchayat Act 1994, first clause, a territorial constituency of Zila Parishad will belong to only one LSC. Okay.
That is one
Okay.
Jila Parishad, one LSC.
Okay, so it may be 4. Okay, LSC shall have 4 territorial constituencies at the rate of 1 member for a population of less than 30, not
Right.
less than 30. Okay. So what is the interrelation between then, because
First is, without Gaon Panchayat, there cannot be any next higher position, next grade. Without that grade, there cannot be.
No,
any
Mr.
Zilla
Pathak, LAC constituencies and parliamentary constituencies have already been delimited.
Police.
Now, that exercise has some relation with this exercise because one LAC will have 4 constituencies per Zilla Parishad other than the town area or municipal area. So, this Zilla Parishad constituencies will be part of Anchalik Panchayat and that will also be part of the Gaon Panchayat.
May I have a fair?
Question is very simple at the first blush. Whether 5 declaration is made or not all over Assam regarding categorization of the district.
And it made whether this is maintained or not.
That is what I am asking for.
Alane, yeah.
Your lordship, the possibly it is not notified.
Then you address on this argument declare.
Yes, what declared?
Aha.
I have to be at final. I don't realize.
Then it is
before that-
no declaration
But before that, I want to.
if something which is in the file and notings
not-
and which is not notified for public consumption,
Otherwise, the objections.
whether it amounts to declaration.
Otherwise, the objections that is called for will be futile exercise.
Otherwise, what did you so? What do in Mahabharata say? Every day the war starts and war ends with the sunset.
My lord,
And day after day,
all mingle around.
all mingle around, both opposite sides. In the morning again, with the war is declared, war starts. Then again they start fighting.
Yes, but they don't see each other on their face.
Yes. So what is the declaration?
Mild. It is mild.
Yes, Mr. Dubey. What do you say about declaration?
Much true, because it's the exercise carried out by the state government.
Not carried out by
Lordship,
state government.
state
Carried
government.
out by the district
This thing
delimitation.
in terms of the direction.
That
of
is
the state
statutory authority.
Okay.
But perhaps your lordship has posed a very relevant question, Lord, that the implication of the exercise of LAC would definitely have a bearing. Because
Yes,
your
sir.
lordship has seen, it restrict the area of one Gaon Panchayat that it could not extend.
It restricts the area of LAC area is defined. Then it defines, it has some correlation with every Zilla Parishad constituencies. And each Zilla Parishad constituencies have some correlation with Anchalik Panchayat. And Anchalik Panchayat
My lord.
will have.
Limited
Because
knowledge,
what has
Lord.
But
happened.
for the entire district, Gaon Panchayat
That is the.
number will be same.
Exactly open to the district delimitation committee. It's a juggle around.
Yes.
Maintaining the.
Yes.
That's.
I can say, perhaps not, they will have to take the base of the LAC delimitation. Working on that base, Lord, they would have to work out.
That
Yes.
is what I am asking, that
What is declared?
for compliance, for compliance of section 5 proviso, there has to be declaration.
Declared.
And that may not be based entirely on population.
But since it is already not.
Defined,
there, now
defined. No,
we will not
but
go-
first question first, what is declaration?
Declaration in my. That to make known
To others.
to others.
That is what I
A
say.
relevant fact or a action or an intent to do something.
Now, what is the authority now?
Authority, I have gone through it. Notification and declaration are inseparably connected to each other. Word notification per se. Word notification per se.
Maybe some difference may be there because
Declaration-
Mr. Pathak, in the Repeal Act 1894, Land Acquisition Act,
Land acquisition, yes,
Section 4 is notification.
that is not.
Section 6 is declaration. If I remember,
Yes, yes,
1894.
Yes, ma'am.
So there is some difference, but otherwise
Yeah. Why?
almost synonymous.
The word declaration.
No,
in
no,
the
Land
context-
Acquisition Act.
Word declaration in the context of the act, that is
Yes.
the Panchayat Act, means a notification in the absence of which the purpose and object of holding a public objection, public hearing becomes futile. Because people do not know for whom ultimately the whole thing has been done.
Here is that a notification to that effect shall be published in the official gazette, section 4.
Of the land acquisition. My lord.
And section 6 says, heading declaration of intended acquisition. There it says every declaration shall be published in the official gazette. So notification to be published in the official gazette,
That is also notification.
in the official
Notification.
gazette, and declaration is also to be published in the official
The
gazette.
moment declaration is to
But
publish.
that situation is not there. Declare
That's why,
works.
my lord, my humble submission will be, my humble submission will be that declaration contemplated under the Land Acquisition Act after being gazetted takes the form of a notification. Because gazette notification meaning is a newspaper or a legal journal intimating the actions of the Crown
Hmm.
for the information of the general public. The moment it is gazetted, a declaration under the Land Acquisition Act, it
Hmm.
takes the shape of a notification.
So if this proviso to section 5, which according to is a condition precedent
Because
in the form of a declaration,
which have to be implemented.
and implementation is different thing.
No, my lord. Population-wise implementation
No.
is possible
No,
only when the
if-
categorization is done.
If the proviso, you say that declaration should precede delimitation exercise.
Yes, that is, yeah, actually,
I think
delimitation is not that LSC delimitation.
No,
It is
section
just
5,
a
we are
figuring out.
understanding. Now, section 5 says that there should be a declaration
No,
of 3 categories of district.
that means they have to apply their man and categorize.
Yes,
District category, let us call it district.
based on
category.
population density or any other relevant
District
factor,
category.
but this declaration must be gazetted or notified.
No,
No, gazetted is not there. But
At
what
least
is
notified. At
what
least
is
notified.
declaration?
The notified means declaration here will be that if this is not notified,
Downward dictionary. What is declare?
if this is not notified,
Downward dictionary.
who is responsible for carrying out the delimitation? The district delimitation committee. Or while he was exercising, he does not know what is his, in which category his district falls. The public who will come to him to raise objection will not know what is the declaration. Everyone will be at dark, and it will lead to an arbitrary exercise of the power.
Permits, one could have thought, just, we'll see in section 5 itself, in the 5, first it says the state government may by notification declare.
Me.
May by notification declare, there the intention is that this.
5,
1, first line. Here the intention is that this declaration should be by way of notification, whereas if your lordship sees the proviso, it says the government shall declare.
It's a misreading of the law, section 5(1)
5.
speaks of establishment of government.
Yes, but
It is not about declaration.
one is, but when there is an intent
The
that
es-
a declaration should be made, but this could be one of the argument. By way of a notification, it's been specifically provided. And when in the proviso, had it been the intent that it should be declared by way of a notification, that notification has to be mentioned. It's not there. But one way of looking at it.
First declaration regard what my learned colleague has said, it is the declaration leading to it's an establishment. কি হল?
Formally announce
It's a formal announcement that this is,
and
but
beginning of a state or condition.
it is a formal announcement of an area as Gaon Panchayat. That is the power of the Gaon. Second proviso, it states how to carry out that power. কি আছে? কি আছে বস্তুগুলো কি আছে? Assembly.
Okay.
This notification, my lord, we have got it. That is ACI's notification. Actually, it is referred to the delimitation that was carried out. That should be taken as a unit.
Okay.
Madam. My humble submission will be the word declare appearing in the proviso encompasses within it an intimation which may be either through a notification or through a Gazette notification. It's an declaration is an intimation communicated through notification or a Gazette notification. Obviously, Gazette notification is excluded, therefore by way of notification. Because I cannot declare, because that is the something, suppose someone says, in my office I have declared. That will not be sufficient declaration. It is must be an intimation, encompasses within it the concept of intimation through the medium of a notification or by way of a Gazette notification, which is not an issue in the Panchayat.
Now, which district it is?
Ekun district. Huh? Kasar district.
Sorry.
Kasar district.
All the repetitions are Kachar.
Right?
One is from
Tomorrow no, A2 kuntu.
First one is Kasar district.
Huh?
Item number 21 is Kasar district.
And how he is calculating as a group B, my lord, your additional affidavit, what he has done, my learned colleague. My
Item 20. Oh, who are you?
তুমি কোন পিটিশন my lord, I may be excused. কোন মানুষটা কোন?
We are the ex actually Panchayat member, the Kabuchak members.
How you are aggrieved?
They are the citizens of residents of that district.
Residents of
Because
that constituency.
they are here using that we want to have a free and fair election in the matter of panchayats, not in violation of the legal provisions. That is how they are confining their prayer and made, because what has happened, an additional affidavit on my instruction he had to file, the petition, my landlord colleague has filed. Since the basis of categorization was not known, in the additional affidavit filed with the writ petition on the very before moving, what he has done and why he has done, I will tell you. He has taken the census figures of all the districts. What are the first category, highest numbers of density of population, second category, and third category. In the additional affidavits, he has found that we come in group B. And that is supported by the draft delimitation order on the right-hand extreme corner. They have referred to 2001 census because they did not have any categorization list. Your lordship will look at the draft delimitation order. On the right, if my memory is correct, on the right-hand side corner, Annexure C. Has your lordship got it? Now that has been now deleted.
Annexure
C at page 40. Since the categorization of districts were not even made known to the District Delimitation Commission, what else they could have done? They have taken
Page
40 extreme right-hand corner.
page 40.
Well, this is what has been finalized.
This is part of draft delimitation order.
It is the draft delimitation order.
And you are pertaining, your case is
We
pertaining
pertain to village page number. We pertain to page number 88.
80,
Annexure H.
Annexure
H.
8.
Yes. And from Annexure H, we have.
No, page.
Page number 88, Annexure H.
Page
of the
88.
My lord. From Annexure H,
88, yes.
we have shown in second column, last column, that they are not following the parameters as group B. Next, page 89 also. They are not within the range because District Delimitation Commission duty was to keep the range, maintain the range that they have not maintained.
No, you belong to which constituency?
Sonai Legislative Assembly constituency.
Sonai. Sonai is 89.
Page 88, it starts.
That is,
88 and 89.
yes. Sonai,
My lord.
Anshalik Panchayat. How many Anshalik Panchayat it has?
It also. Anshalik Panchayat data.
Banchkandi.
15, my lord.
Data.
Sonai Constituency 1580.
Is
What is
right
what is the exact grievance?
exact grievance for
Let us take, for example, first row, Banchkandi,
Banchkandi.
Sidipar, Manipur.
they are maintaining at 7,900. Has your lordship got?
Hmm?
Now, your
No. Let us understand first, page 88,
My lord,
first row, Banchkandi.
my lord. I have no problem.
Huh?
I have no problem. I have no problem.
No
Because they are problem. Maintaining it 5-1.
No, in which,
Serial
where
number-
it is problem?
Serial number 2, serial number 7.
See, let us understand first.
Yes.
Banchkandi, Gaon Panchayat, Govindapur, Algapur. It has 4 villages.
My lord,
Then you said about population,
my lord,
2021.
my lord.
So you added the population,
2001.
2001 census, you
And-
added the population. It comes to 7,935.
My lord. And your lordship will now come to section 5, Roman B, alphabet B. Category B should have been within the range of 8,500 to 11,500.
Now tell me, what is the total population of Kachar district?
This is the additional affidavit I have. Kiman ase? My lord will bear with me for it. Kiman ase? Apuni janibo. Kiman ase? Population Kasaro? Total population? Huh? Alright. Huh? 3 lakhs, this is.
14 lakhs more than.
Huh? And what is the area? What is the population density of Kachar district?
Oh, I don't ask. That is there.
Oh.
In the additional affidavit, I have stated the
Population density of
Additional
Kachar
affidavit
district.
Additional affidavit from there. At page 91, it starts additional affidavit. Page page 94. Your Lordship,
Population density.
density, the district having medium density population as per 2000, has your Lordship got it?
Is
Page 94.
$94.
Mile.
Hmm.
First subparagraph, the district having
Hmm.
the district having medium density of population has a Lordship got it?
How you have arrived at the figure?
From 2001 census.
What is the area? Have you mentioned here?
Yes, my lord.
Actually, having highest density.
We have arranged it because the problem was
Kamrup. Kachar.
next page is Kasar.
Kachar. Where is Kachar?
Page 94.
Page 94. Population density?
Population density is, my lord, 432 per square kilometer.
Hmm?
Followed by Hailakandi was at 409.
No. Where? Population.
I am reading out from page number 90.
Page 94. Yes.
The district having minimum density of population as per 2001 population census
Are like Dorong.
with 432 per square kilometer, followed by Hailakandi district was at 409. Shivsagar district was at 395 per square kilometer. Lakhimpur district was at 391 per kilometer. Kasar district was at 381 per square kilometer. Bongaigaon district at 361 and Jorhat district was 354. The aforesaid district having medium density are fall in the category B51. The district having lowest density of population, unlike Dibrugarh district, was at 347, followed by Sonitpur district was at 315. The Tinsukia district was 303, Kokrajhar district was at 294, Golaghat district was at 270, Dhemaji district was at 176, Karbi Anglong at 78, Ansi Hills was 38. The aforesaid district having lowest density of population are fall in the category of C as per section. Because why I am referring to 2001, my lord, in the draft notification, since the classification was not done, they are referring to 2001 census. Without category, that implies that categorization was yet to be done. So I myself have done the categorization. It was university. University. It was university.
Draft delimitation is page 40.
My lord.
No, where is the population part? The draft
Yeah,
delimitation?
my lord, you'll see draft starts at page
40.
40. Huh? Draft of diya nahi. Oh, achha, draft of diya nahi. My lord, I'm extremely sorry. Draft of diya nahi. I'm sorry. I stand corrected. Draft, they have not shown the population figure.
Yes, not shown.
I'm sorry.
There is no population figure at all.
I do not know. I am sorry. Extremely, I apologize at this level. It is on the basis of 2001 they calculate.
There is a mention that census 2001 code of the village. Please see 240, page 40. I was thinking that the population figure was there. There was a mention about census 2001 code of the village. Extreme right.
That means 2001 census has relevance.
Maybe in what manner, I don't know.
I also don't know. My lord.
I don't know. Because see the, I don't know what is LGD code. There is, you may see the first row,
My lord.
serial number, name of LSE, name of GP after delimitation, LGD code of the GP. If GP name is same as erstwhile GP delimitation, name of GP before GP delimitation, name of the villages, LGD code of the villages. I don't know what is LGD. Census 2001 code of the villages. There is nothing regarding population here.
Which-
Population here.
I am at least not aware which is the basis.
What is the basis? I also don't know.
Problem at least, if I don't know, your lordship also is,
Oh, no.
I wonder what exactly is the objectors did. What did they, what was their objections? They are not, if they are kept at dark, the objection will be a futile objection. Their duty was to categorize it first. May I take one more in that? This situation arose in a, lordship might be aware, the DMK case. DMK, Dravida Munatra Kazakam case. That arose, all these points that after we have, that was a Gaon that no, nothing can be done. Then Supreme Apex Court said, it is not like nothing can be done. We can exercise our jurisdiction. That to subserve the process of election, ultimate election, they directed the government to do, because they are Tamil Nadu Ekhon that follow the Tamil Nadu process, entire procedure, and thereafter hold the election. Doesn't it, Tamil Nadu? Paragraph 11, 12, 13, 14, and 16. I will not read out, I think I am taking a lot of valuable time.
No. I am trying to find out what is the exact case.
Exact, yes, exact
What
case,
is
if I
case
can-
to be decided. Otherwise, if I don't know
Yes.
what is the
Yes,
exact
I-
case to
I
be
appreciate.
decided,
I appreciate.
because government is silent about declaration.
That doesn't
You are
absolve-
saying there is
that cannot absolve their duty to.
no,
speak out.
we don't know, and Section 5 may by declare any this Section 5 subsection 1 main substantive
power.
provision that has been declared.
No, that has been now declared. Yes, that is the power is given.
That is given.
Procedure for
But
carrying out their power.
Condition precedent about declaration, whether that is there or not, and what is declaration.
My lord, I am obliged. And
Okay.
whether it is mandatory or directed. That is another argument.
Yes.
It may come that this is
But-
not mandatory.
Understanding the meaning of declare
Declare, my lord.
in a election matter to be an electoral process which is going to be
Taken.
taking place.
That exactly has happened in that DMK case. I have given paragraph 11, 12.
Or I'll just resume.
Can I come back after 5 minutes? Then I can agree. DMK case today. More can My lord will come from paragraph 11. Before paragraph 11, the rival contentions were discussed. May I read, ma'am? Having heard the learned counsels for the parties at a considerable length and after an in-depth analysis of various statutory provisions as well as the constitutional scheme under Part 9, which envisages democratization of grassroots level administration, we are of the view that as per Article 243B, panchayats have to be mandatorily be constituted in a state at the village, intermediate and district levels. Article 243C requires the state as far as practicable to maintain a similar ratio between the population residing within the territory of a particular panchayat. Hello, rest, can he read it out, my lord? If you lordship so. What's that, my lord?
A similar ratio between the population residing within the territory of a particular panchayat and the number of seats allocated to it across all panchayats in the state. further each panchayat must be divided into territorial constituencies and per article 243D, seats in proportion to their population must be reserved for scheduled caste and scheduled tribe in each panchayat. Then my lord, paragraph 12.
1 minute.
Lordship. So may I continue?
Okay, no fine. Right.
Mr. Pathak, just that one. But again, I'm going to 243C.
My lord.
Requires the state as far as is practicable to maintain a similar ratio between the population residing within the territory of a particular panchayat, Gam panchayat, let us read, and the number of seats allocated to it across all panchayats in the state. What does it mean?
That means, suppose there are 24 districts, suppose. Total number of all panchayats. Total, because I'm again, my lord, the problem will be. the
Again
pro-
here, yes,
Because Apex Court has noticed it,
noticed.
but subsequently next page, Apex Court has gone in a different tangent at paragraph 13.
Okay, but here, what is again, I am asking you repeatedly, because across the sea, between the population residing within the territory of a particular panchayat.
Let us stop here for a moment.
Stop there for a moment.
Population residing within the territory of a panchayat.
Particular panchayat, particular.
Suppose X.
One Gam panchayat.
Let us call it X.
Because it has 3 levels.
My lord.
Intermediate village, intermediate and district.
Now we are panchayat.
Gam panchayat. Particular panchayat, let us read as
Yes.
Gam panchayat.
Let
The
us call it,
population residing within the territory of a Gam panchayat.
that is, let us call it X. X amount.
Gam panchayat.
Yes.
And next part is the number of seats allocated to it. Okay, this is another part.
That means to the Gam panchayat.
Yes.
To that particular Gam panchayat.
Across all panchayat in the state. Now, does it mean?
I'm getting some meaning in that. Now,
Does it mean
yes.
that 10,
My lord.
10,
10.
section 6.
The Gam panchayat shall consist of 10 members.
Each Gam panchayat has 10 members,
Yes, my
10 wards.
My lord. That means X is known now is equal to 10. For the convenience of the
Whether Gam panchayat 10 across the state. See, across all panchayat in the state.
My lord,
If we take Gam panchayat level, then every Gam panchayat will have 10 wards. Does it mean that?
No, may I interrupt here for a moment?
Yes, sure.
Here the 243C, my one understanding was, let us call it requires the state. Let us bracket it because requires the state to carry out this across the state. That means it requires the state in as far as practicable to maintain a similar ratio. That means state will maintain this similar ratio. What will be the ratio? Between the population residing of a panchayat and the number of seats allotted to it. That means it means that panchayat. And this ratio will be followed in across the state.
Hmm.
This is my understanding.
So that understanding results into what?
If X is, suppose X is now fixed. Population will be a variable, Y will be variable. In a ratio, X is now fixed by 10. If the Y is a variable factor, then panchayats need not be fixed all over the state, number of panchayats. I'm speaking like a government advocate now. Let me now think it
Request
from
the
the government
state
side.
to maintain a similar ratio, because I am asking you for a different reason. Request the state
Request the state.
to maintain a similar ratio.
Otherwise, the word have been same ratio.
Huh?
Otherwise, the word have appeared in the same ratio. Similar ratio.
Similar ratio, there is no harm if one maintains same ratio.
No harm if X is part. Yes, no harm. Yes. Your lordship is correct. Yes. I've got it.
If it is same ratio 10,
10. X is 10.
10,
Y is variable.
which one?
Same ratio
Between.
between the population residing within the territory of a particular panchayat, let us call it X, and the number of seats allotted to it.
I am not
It is a
understanding
fixed
it.
ratio.
I am very frank about it, not understanding it. Say for population residing, I'm just making an empirical study.
While
Suppose Gaon Panchayat area is defined. Suppose,
it is.
let us, for
Let us call it
ease, 100,
My lord.
100%.
My lord.
Okay, that is that is there.
My lord.
Now, what is this number of seats allocated to it?
Number of seats 10.
10.
Yeah.
Then ratio is to be, to find out the ratio, 100 is to be divided by 10.
Yes.
Then result is 10.
No. My lord, one thing. The population residing within the territory of a particular panchayat, this is, let us call it Y. Population. This will be always it will be a variable.
Variable.
But X is fixed, 10. Because fixed by the act. X is fixed by the act. X is fixed by the act, and the population residing within the territory of a particular panchayat. This population is a variable factor.
This population residing within the territory of a particular panchayat is to be divided by the number of seats allocated to it to find out the ratio.
So that population is a variable factor.
If population becomes a variable factor, the result will be variable.
Result will be variable. So some district, that's why the problem is most probably that is the reason why categorization of this population has a logic. Now I get the connection. I'm obliged. That population, what is the logic behind it? I was A will be this. A has more. Has your lordship got it? Your lordship will kindly come to section 5. They have given a scale, ABC scale. ABC scale they have maintained correctly that A is the scale, more is the population. B is the scale, less is the population. C is the scale, lesser is the population. The uniformity is maintained. It is a scale of population. The grievance is for not maintaining the scale. That means section 5 proviso ABC are in consonance with 243C. Because Constitution provides all people shall have proportionately equal representation.
Because 243C is constitutional provision. And under chapter 9, state by law,
State by law.
it is subservient to the constitutional provision.
Yes.
And if there is some inconsistency, it will be a constitutional provision which will prevail,
Madam.
I think. Now that is why I am trying to understand your challenge in the writ petition.
Regarding implementation.
Yes.
But why
Oh.
I am not, my lord, only one thing. Presumption is the
But reading and reading, still I am not understanding. I think one
Lord.
empirical example, arithmetical example will make me understand. I am very,
I tried my level best, to be very honest.
by an arithmetical example.
I tried XYZ, I tried by mathematics. I could not arrive at any figure. That's why I was not going to that chapter.
Because let us read this further than this judgment.
My lord. The Supreme Court also, interestingly, has not gone into this aspect of the matter. Your lordship will read the next paragraph and only 2 paragraphs left.
Yes.
May I read from paragraph 12, my lord?
Yes.
It is thus clear that the constitutional object of Part 9 cannot be effectively achieved unless the delimitation exercise of the constitution of local bodies at all levels is properly undertaken. Such exercise in the state of Tamil Nadu must keep in view the criteria of delimitation, has your lordship got it? Words prescribed under the so and so, the local act, my lord, formulated under the so and so act, which criteria must itself not be contrary to Article 2.
That is why I am asking you.
Yes.
That is the question arising in my mind, that how this
How
243
this
compliance,
from this, whether it is in consonance with 243C.
if this is not, but the action on the part of the state is in consonance with 243C, then this proviso may have to give way to 243C. This is why, which criteria must itself not be contrary to Article
That means it has
243C.
been left to the government to again decide. If your lordship says,
No,
Apex
you
Court-
have to make me understand, Mr. Pathak.
I understand.
That is what I'm
Before
asking.
the Apex Court also, with all due regards to the Apex Court left this exercise to be done, that do it in consonance, but did not even go to that.
No, which criteria?
Which
criteria? Please see this one.
This
Very
criteria.
pertinent.
Yes.
This criteria, because they have referred to some local bodies delimitation regulation.
Yes.
Here it is SOP or whatever.
Yes, sir.
Whatever, and this particular law, which criteria must itself not be contrary to 243C of with article so and so. Now, if my question about 243C is say 10, be what it may. If it is 10, is 10.
It cannot be ABCD. It cannot.
That is why I am asking you to.
That matter.
Something has stuck in my mind.
If in between I get an appropriate, some kind of, not an.
That is
I should not call it
logically. Okay, let us read further.
I'll have an indulgence to come immediately back only for 5 minutes to place it tomorrow. Only 5 minutes or 2.
Okay.
I'll just come and intimate you.
Okay.
If provided it comes to my mind.
Because
Paragraph 13.
uh-huh.
Noticing how the completion of delimitation process, there were only 31 revenue districts. But despite subsequent increase in the number of districts to 39, no fresh delimitation exercise has been undertaken. It is clear that the state government cannot fulfill the aforesaid constitutional mandate. There is no, now it's more or less similar, now it's coming. There is no identifiable data elucidating population proportions, as a lordship. It's now coming to that side. And hence, requisite reservation for scheduled castes and scheduled tribes cannot be provided for, both in village panchayat wards and so. We hence have no doubt that the election process, as notified by the State Election Commission, in that case, my election notification also was out, cannot be held unless fresh delimitation exercise in respect thereto is first completed. The state government cannot justify holding local body elections of these 9 districts by relying upon the court's order, it is the interim order, as the said order itself mandates that notification of election only after completion of all legal formalities. Now some directions have been given, paragraph 14. The contention of the respondents that the present proceedings amount to calling in question an election, quote and unquote, and hence not being maintainable in view of express constitutional embargo of Articles 243O and 243ZG does not impress us, for the present proceedings are only to further the expeditious completion of prerequisites of a fair election, as the lordship. Hence, the following ratio of a coordinate bench in Election Commission of India versus Ashok Kumar 2008 SCC squarely applies to the present case, Roman 2, numerical 2. Any decision sought or rendered will not amount to calling in question an election if it subserves the progress of the election and facilitates the completion of the election. Anything done towards completing or in furtherance of the election proceedings cannot be described as questioning an election. Subject to the above, an action taken or orders issued by the Election Commission are open to judicial review on the well-settled parameters which enable judicial review of decisions statutory bodies, such as on a case of malafide or arbitrary exercise of power being made out or the statutory body being shown to have acted in breach of law. Without interrupting, obstructing, or delaying the progress of the election proceedings, judicial intervention is available if assistance of the court has been sought for merely to correct or shorten the progress of the election proceedings, to remove the obstacles therein, or to preserve the vital piece of evidence if the same would be lost or destroyed or rendered. For the reasons aforesaid, these applications are allowed in the part and disposed of with the following direction. Now, A, we are not concerned. B, my lord, has a lot got it. B. The respondents, including the Delimitation Commission, in that case, man, it was State Delimitation Commission, are directed to delimit 9 newly constituted districts in accordance with law and thereafter hold elections for their panchayats at the village, intermediate and district levels within a period of 4 months. Even the time was given. There shall be no legal impediment against holding election for panchayat at village, intermediate, or so and so for the rest of the district. Here the problem was with 9 districts. State Election Commission shall notify elections for the panchayats at village level so and so as per the schedule below. Paragraph 15. In all fairness, we must note that the learned Advocate General of Tamil Nadu has also agreed to proceed with the election process as directed above. As a lordship. Since the only grievance remaining is a contest. Now, this was not the first case regarding judicial power of the panchayats, my lord. One decision is already reported. But baki all of it is a division bench. ভোটৰ কাৰণে মোৰখন ডাকমৰা থাকে, ডাকমৰা আছে। ডাকমৰা কপি লাগিছে নাই, ঠিক আছে।
1, 2, 3, 4, 5, 6, 7, 9, 1, 2, 3, 4, 5.
এইটো বৰ হালধীয়া মাৰ্ক কৰা আছে। আৰু এইখন নিদিবা, মই এইখন পঢ়ি লওঁ প্ৰথমতে পঢ়ি লওঁ গোটেই।
6, 7, 8.
মোৰখন পঢ়, মোৰ এটা কপি আছে ন।
In the notification, page 60,
My lord, my lord. It is
this
covering the
is
entire district.
Gaon Panchayat under Kachar district.
I am not concerned with all the guns.
Ah.
I am at page number 88. Annex
88.
My lord. 88 also I am not concerned with all villages. Serial number 2, 7.
88.
Entire villages I am not concerned with.
Page
Page 88.
No,
Annex
show me from this particular notification.
some. Annex H, my lord.
Because we have to test this
Yes,
notification.
my lord.
Which part?
Except from the draft, my lord.
No,
Or
yes.
From Annex H I should show.
No, page 60.
Page 6. Yes. It কোনখিনিৰ পৰা আছিলে মই লাষ্টৰ ফালে আছে আৰু। Yes. My lord will see it at page 79. It starts.
79.
Yes. Serial number 11.
79. 79.
Serial-
Bachkandi.
Next is Baskandi Panchayat.
Anchalik Panchayat.
Baskandi Anchalik.
Okay.
Then next page 80, Sonai.
Out of Sonai.
Sonai Anchalik Panchayat.
Bachkandi Anchalik Panchayat. Sonai.
Then-
Which particular?
এখিনি আছে no? These are the two Anchalik Panchayats. Because petitioners, they are before lordship is from this.
Now, how many Gaon Panchayat in Anchalik Panchayat in Kasar district?
Kasar district
Mr. Chaudhary? Not Mr.
Total 163.
No. I'm not saying about that. Anchalik Panchayat.
Anchalik Panchayat total.
1, 2,
15.
3,
1, 5.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 15 Anchalik Panchayat. Now, whether each Anchalik Panchayat has same number of Gaon Panchayat under it?
I think 163.
No, I'm not saying about that.
Oh, that of course.
This,
Right now.
it is not from the,
That's.
there are two
No, but that's-
view about the same thing. I think Mr. Pathak, no, that worm's eye view and a bird's eye view.
I know.
Worm's eye view, we are looking, you're projecting the figure from the worm's eye view.
Yes.
But we have to look,
No,
court has a
yes,
duty also to see from a bird's eye view.
Sometimes it's mismatch.
Mismatch.
Very often mismatch.
Then that what subserves the justice has to be looked into. Now, each Anchalik Panchayat, have you calculated? Have you calculated each Anchalik Panchayat have how many Gaon Panchayats?
পঢ়া নাই। আইদার করিছো নাই বা নাই করা নকৰিলে
Yes,
আমাৰ
yes.
Did you, have you done that exercise?
But here is মানে page 79.
No, that will not do. I'm arithmetic wise.
may I have an indulgence, Your Lordship?
Sorry.
On the next date,
Sorry.
I'll make the calculation. Your Lordship will not take the burden, man. It was my fault.
5,
I did not make the
6, 7,
calculation.
8, 9, 10.
Hmm?
No, I'll just have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. I think every Anchalik Panchayat appears to have 10 Gram Panchayat or
Somewhere 9, somewhere 15.
9 to 11. 9 to 11, it appears. 9 to 11.
I'm sorry that I should have done this homework and now I could not.
No, from the births, I view.
My lord, I assure your lordship, I'll recalculate it because I do not know exactly. What I don't know exactly at the moment is difficult.
Yes, Mr. War, you please do the exercise.
Yes.
How many? Most of them 10, perhaps. Each Anchalik Panchayat has 10 because they have to fulfill that
That
32 also
yes.
and 64 also.
Yes, I understand your lord.
We are exercising some
Within that parameter.
pyramidal structure has to be as far as practical in conformity to 243C as well as proviso to section 5. Now, each Anchalik Panchayat has about more or less 10,
Yes. More or less.
but it has to be 10. Otherwise, huh?
One thing, my lord, in the fact of my constituency, my lord, there are two Anchalik Panchayat. The first Anchalik Panchayat, there are 10, Anchalik, there are 10 Gaon Panchayat.
Hmm?
There are 10 Gaon Panchayat. And in the second Anchalik Panchayat, my lord, that is Sunai, there are 9 Gaon Panchayat.
Hmm.
So all ratios are not same.
Heading by.
That is section 32, but more or less.
More or less.
Similar, whether that is why I am repeatedly asking Mr. Pathak, what is this similar? Population within a panchayat at each level to the constituency allotted to it. I am repeatedly asking.
Actually, what happened? The whole crux of the problem is there is word or either population or any other. Has your lordship got it? Section 5. Section 5 condition.
Before section 5, I am actually looking at 243C, which is the constitutional provision.
But I restrain myself because of another problem. Why I am harping on that I want implementation of it, section 5. There is a reason behind. Whether it is ultra virus or not, that cannot be ascertained unless we know the true meaning of that Article 240.
That is why.
Because when we are going to say a law made by the legislature to say that it is ultra virus, we must know exactly what does it mean. What does that, because here your lordship will see this burden, this particular issue that has fallen from your lordship, I have checked up in the morning. No one is trying to go into exactly what it means. 243C. Even the apex court just now, your lordship, government is now directed to follow this. Your lordship will see the in-between line. Because whether that particular rule is ultra virus to the 243C.
We are not deciding by virus.
We are not deciding.
But we are trying to find out how this can be read together. If it cannot be read together,
my humble submission,
then this provision might have to give way for 243C.
My lord.
That is why I am, because from the top-down approach or from bird's eye view.
Being a senior counsel, if I'm not sure of, so that's why I have not delved into that situation now. I might, without understanding myself, it will be a difficult area where I should not try to swim in.
Because let us read 243C once again.
My lord, I have. May I bend down?
Yes, yes. Subject to the provisions of this part means every part.
Every part.
The legislature of a state may by law, that is Assam Panchayat Act,
Assam Panchayat.
make provisions with respect to the composition of panchayats.
They have done it.
So subject to the provisions, that proviso also includes, provided that the ratio between the population of the territorial area of a panchayat at any level, all three levels, and the number of seats in such panchayat to be filled up by election shall, so far as practicable, be same. Here it is same.
Constant figure.
Figure is constant
I don't.
throughout the state.
But
First line is subject to the provisions of this part. The legislature of a state may by law. So that law must be subservient or in conformity with this part. Make provision with respect to the composition of panchayat. Composition means
No,
how many at each level.
a constant ratio will come out.
And this has been, that is why Mr. Pathak, I'm repeatedly asking whether this is the figure that provided that the ratio means what? 10 divided by 2, say,
And that is
should come to
1 divided by 4.
ratio between the population of the territorial area of a panchayat at any level, all three levels, all three,
Yes.
and the number of seats in such panchayat to be filled up by election cell, so far as practical, flexibility, but at the same time be the same throughout the state.
But then the ratio, we get a constant ratio for the.
Constant ratio so far as practicable.
But anyhow, constant ratio means.
Whether that ratio, suppose me, I am just asking you, that is why I've been repeatedly asking you, that whether Zilla Parishad, every Zilla Parishad should have more or less the same territorial constituencies that is elected by election. See, to be filled up by election. Maybe I may be asking a irrelevant question, but
No, no, no,
still.
but it's a thought-provoking issue.
So, Anchalik Panchayat, in most of the Anchalik Panchayat, all throughout the state, if it is said, because Anchalik Panchayat, from each Gaon Panchayat, one is to be elected. It is almost 10 or 9 or 11 maybe. Maybe, I'm not sure.
Yeah.
Then it boils down to, again, Gaon Panchayat.
Ultimately, the foundation of the freedom.
And that Gaon Panchayat will have 10 again. We'll have 10 again. Now here, I think new provision that Gaon Panchayat president is not to be directly elected.
Yes.
Among the members.
Like among the members, he is to be elected later on. So that
That's
provision is
within the
gone.
buffer.
So each Gaon Panchayat will have 10 by section 6.
My lord.
So if you come down from there, whether this proviso required a state, that is what, that one, without further elaborating, to maintain the same ratio as far as
Then
practical.
in that case, section 5 will go.
Then
I will
because
go.
that is not under challenge, I'm not.
No, because my lord, problem is the people here, the petitioners, they want immediate election. Now for the time being, they are not delving into that issue that election should be held up. Their consideration is that this section 5 should be implemented because
Yes,
their main purpose is to have the election by following this.
section 5.
Section
Okay.
5. But I have got, if we
And
go the
this
section,
cannot be read dehodes the other constitutional provision. That is why I'm asking you.
Section 5 will go.
But,
Another thing, there even the rule is in ultra virus to the act.
So no, that is not a
I
challenge.
am
So
not
I am
coming,
not commenting on
But
it.
if my colleague,
But if the this thing is to this constitutional provision, if I have read correctly, or that is why I am been putting, I am not sure about it. If it is to be read in that manner which I have indicated,
if that is the purpose, what they exactly, then 5 is immaterial. 5 is immaterial.
it must have to give way to 243C.
Here another problem. Let me say, because I think he is a senior counsel now, he can at least communicate. My understanding of the rule, it is also he speaks in a different time.
Right. So that is why please
One
make
rule
me
does not
understand
take
by
into
an arithmetic example by tomorrow.
rule. My lord, I have personal problems.
No, you can just hand over so that you just hand over to Mr. Chaudhary or just an arithmetic arithmetic example of 243C proviso. And that will make
In
me
my
understand.
limited understanding, definitely he will convey. This is not a point of debate here. Rule is in ultra virus to the act. Act is ultra virus to 243C.
That is what, if since we are not
But
deciding that question.
We have to go by the instructions.
Oh, is
They-
sure?
Instruction is they won the election, but following 5. So sometimes I am harmonizing amongst everything now.
I am not sure about my interpretation of
No, my lord,
243C proviso. That is why I am asking
I
that
will look into it.
how it is this similar thing is to be done, because Gaon Panchayat cannot be looked into in isolation of Anchalik Panchayat or Jila Panchayat or the LSEs.
Hmm.
Let us be sure about it. And all these things have to comply, say Jila Parishad, Anchalik Panchayat and Gaon Panchayat have to comply with the proviso to 243C. And if that 243C is not in conformity with this proviso to section 5 about categorization of district.
That will complicate the issues for the government.
Further.
That
No, we can decide on that. Because your whole case is under the proviso to section 5.
Proviso, because
And court has to look into everything.
my limited case was, because I don't want to create issues for that.
Sure.
My limited cause is, there is a power in the main section. There is a declaration second. Third is how to carry out through delimitation. Because if purposefully, I have not delved into it, to be very fair. Because people at the block level, grassroots level, they won the election. But by following this is the limited prayer.
Right.
Because taking this opportunity only, I am saying, I am not making an issue. Definitely, he is the principal chief advisor to the government. Rule appears to, if my limited experience.
Which rule?
Some Panchayat constitution rules.
Is there any rule also?
Rule 6. That appears to be totally in contravention of the act. Act appears to be in contravention of the constitution, one after another. But I am not making any issue, man. Only just a
Delimitation of constituencies.
rule 6.
Rule 6.
The lordship will look at the entire last sentence. Yeah.
Sub-rule 1.
Yes, madam.
Yes, immediately after declaration of government under subsection.
On the basis of household. Has your lordship got it? Household is one thing. My house number is house number 39 at Panbazar. I can have a population. I have a population of around 20 persons.
That I have understood. I have understood what you have said.
The lordship.
If
But this should not be a point of
no.
Because it is our duty from the bar to at least bring it to the knowledge of the.
At least the idea. Yes. say there are 10 households. 10 households. And each households are joint family. Having 20 members,
My lord,
then it will be 200.
my lord, now
And in the other one, 20 households having nuclear family, 3 members, it will be 60.
my lord,
Simple.
simple. And that is the problem.
That
Someone
is a debate
I
for
understand.
another.
But at least I have taken this opportunity because India, this is a matter where Advocate General will be appearing. So at least it is my duty to convey exactly what I feel about it.
Okay. 243C, you just
My lord,
make me
definitely it is
understand
not-
clearly, because or any authority is there of the Supreme Court, then you can just hand over tomorrow,
My lord, I will
so
try.
so that I can go through it and for your submission, further submission, anything.
No,
Thursday.
only one. I am representing Hailakandi Nekar. Tumatmi Haila. Another with petition, Hailakandi, the same law points. Hailakandi ne Morigaon. Hailakandi C is from Morigaon.
Ah.
They will give the numbers at 2 o'clock, my lord. Same points, no classification done. Same group B, same legal argument. Factually, he will tell certain facts. Parimana facts. My lord,
Okay.
may I take your lordship's leave?
But Thursday, possible for you?
Aji keep it. I will try, my lord. Definitely, I will try. It is a very interesting issue, but for some problems at home. I'm not-
Okay. If 10:30, I can hear you without any trouble. 10:30.
My lord, I do.
Other side will be available, my lord. Petitioner General.
No, let me understand 243C from
My
Mr.
lord,
Pathak or Mr. Chaudhary. Mr. Chaudhary can also address on 243C proviso.
Seen, my lord, but that
Ah.
is once 5 is not under challenge.
Huh?
Once section 5 is not under challenge, so suppose, my lord, if.
No,
I
because
understood from that agreement, my learned friend.
what I am saying that Mr. Pathak, that one side view is different and bird side view is different. Because we have to look into the constitutional provision. And if the section 5 appears to be not in consonance with 243C, then it must give way.
But one thing, my lord, there is another request for no relief a relief that is not sought for cannot be granted.
Which one?
Now, suppose it is ultra virus.
We are not
No.
deciding on ultravirus.
That is not a question, my lord.
I am not delving into that.
But standing alone, section 5, amended section 5 cannot be looked into without
243.
243C. As a constitutional court, we have to look into 243C. Otherwise, just from bottom-up approach, we cannot adopt. You might have argued it.
That DMK case, they have avoided it.
Huh?
To be very fair, I'm talking. DMK case does not have this.
Huh.
There is in between lines.
Yes,
In between lines is there.
I have seen.
Leaving the entire problem to the state government again.
So he is indicating, my lord, here also in between line is to taken.
Yes, Mr. Chaudhary, if Mr. Pathak has some difficulty, can you fill up?
I'll
That-
try, my lord. I'll try, but I think he will.
In some other matter, I am appearing for him.
If-
Now, he should not at least,
Huh.
he
If,
should not.
if
hit me back from
it
the-
is not possible for Mr. Pathak day after tomorrow, then you can, 10:30 will take up.
Day after tomorrow, we have problem.
You have problem.
Except the.
No, we are not concluding it. We'll conclude the submission of the petitioner side. It is-
Difficulty can আজি কৰিছো. At least he should not misunderstand me that in his absence I have said.
No.
No, no.
You'll be there.
I also. Out of state.
No, we'll hear since we have. No, ঠিক আছে শুনিলাম এইটো day after tomorrow. But in the meantime, if you can find something on 243C and how it is to be interpreted,
I will again write.
or has been interpreted already,
No, it
then
has-
just hand
has-
it over
I think no.
to
This
the
is a
court
statement
master
from-
through your associate. Yes, Mr. Hussain.
This is a statement from the bar, it has not been.
And
This is
plus one arithmetic example.
My lord. X divided by Y is a
Whatever.
constant.
Uh,
My understanding
Say
is a constant.
population is
It will remain constant.
1 lakh. How it is to be same? The ratio, how it is to be same? Or say similar?
Well, problem is in a constitution, same word is there, but not
Huh?
similar.
Huh?
Proviso, same word is there.
And then before that,
There is
as
no-
far as practicable.
So some flexibility also there. man.
Flexibility is also there. And here in the act, it is, I think, similar.
Yes, similar.
They
Yeah,
have
category-
interpreted
yeah,
as
category
far
is
as
that.
practical and same as similar.
Yeah,
Similar
category
is like 1/4 is equal to 2/8.
Yes.
2/8 is equal to 16. These
Yes,
are
yes.
all not same, similar.
Ah.
It is same
But-
proportion,
Ah.
but similar also. 1/4 is equal to 2/8.
Okay, show me. I'll understand. I am
Up to that point of.
I am-
Not belongs to arithmetic department.
quite dull in that.
Only he can enlighten my. I do not,
Now, we succeed-
I have no ABC idea about the arithmetic.
Okay.
He's trying
Alright.
to excuse.
Mr. KP Pathak, Learned Senior Counsel, assisted by Mr. H.I. Sudri, Learned Counsel for the petitioners. In, you are appearing for in all the cases?
On
No,
two- one,
I am for item number 3 of today's. Regular
Okay.
list.
I'm applying
21 and 22?
21.
Okay, both. And Mr. M.K. Hussain, assisted by Mr. H.I. Sudri and Mr. M.K. Hussain in writ petition number item 21 and 22. And Mr. H.I. Sudri,
For item
Learned Senior Counsel,
3 of it.
assisted by A.H.M.R. Chaudhary for the petitioners in item 3. The Learned Senior Counsel for the petitioners would advance further submissions on Thursday.
Well.
List the cases accordingly on Thursday.
and
We'll
failing
take up
which, failing which Mr. Sudhi.
Yes, yes. That is understanding. That will do. And
No adjournments will be given. I
10:30. Understanding is 10:30.
Yes.
Lordship, the- on that day, your lordship, the petitioner part may become part only.
Mr. K. Kaur, Learned Additional Advocate General for the state respondents,
Notification number given.
and Mr. R.K. Dubey, Learned R.K. or R. Dubey, Learned Standing Counsel, Assam State Election Commission for the respondent ASEC are present. তাৰপিছত we will list the cases accordingly on Thursday.
I have another matter coming up. I have another matter coming up at 2 pertaining to her. That, who is this? Morigaon.
Morigaon.
That is unlisted she mentioned.
Okay.
That
Same thing, it will be fixed on Thursday. Okay, you make a mention at 2:30.
I think
Affidavit in reply, Lordship, the respondents have, respondent number 2, 3, and 5 have filed their affidavit in opposition.
Okay, state respondents.
Yes, Lordship.
Two, three.
2, 3, and 5, Your Lordship.
Your name, please.
S. Sharma on behalf of D. Chaudhary.
Learned Miss S. Somu, Learned Counsel representing the respondent. Appearing for a respondent has prayed for and is granted. How much time?
2 weeks' time, Your Lordship.
2 weeks time to file an affidavit in reply to the affidavit of opposition filed by the respondent number 2, 3, and 5. This is the case accordingly after 2 weeks.
Have you obliged?
Item number 1 from production list.
Thursday. Okay, on the pair of MS S. K. Nargis, Learned Counsel appearing for the petitions, list the case on Thursday. Mr. K. Kaur, Learned Additional Advocate General for the state respondent, and Mr. is present and has agreed to the state's prayer. First of list the case according. Yes, Mr. Deka is available. because Decca is important. Call him. Mr. Decca, State Information Commission. We have asked him to be present. Please call him.
Admission item number 4, 5 and 6. Lord, may kindly take item number 5. My lord, in this case, we have challenged. My lord, in this case, we have challenged provisional assessment orders and a notice, my lord. Now, what had happened? Now, we have been sought to be construed as, my lord, alleged Benami.
Benami.
Benami, yes.
Okay.
Now, what had happened, if your lordship would kindly come to page number 45. That is the unamended provision, my lord. In terms of which, even if we construe the allegation of the department, then it will not be a Benami transaction. Please come to 3.2, my lord. No person shall enter into any Benami transaction.
What is
Subsection-
Benami transaction?
Yes. Benami transaction means 2A, any transaction in which property is transferred to one person for consideration paid or provided by another person. Now, my lord will kindly come to 3.2. Nothing in this subsection shall apply to the purchase of property by any person in the name of his wife or unmarried daughter, and it shall be presumed, unless contrary is proved, that said property had been purchased for the benefit of wife or of unmarried daughters. It should be all. No? Wife, it should be or the unmarried daughters.
Okay.
Now, my lord, this particular provision was amended by amendment made in 2016. Now, if your lordship kindly takes the act, my lord,
Benami
Prohibition
transaction.
of Benami Property Transaction Act 88, amended in 2016. Now, my lord will kindly come to the definition section. Two 9 defines a Benami transaction. Benami transaction means a transaction or an agreement.
Arrangement or agreement?
Arrangement, my lord. Or an arrangement where a property is transferred to or is held by a person and the consideration for such property has been provided or paid by another person. The property is held for the immediate or future benefit, direct or indirect, of the person who has provided the consideration. That means the the beneficial owner. Now, in this case, my lord, beneficial owner, according to the allegation, is one Mr. Durlabh Somowa, and Benami Darar, my lord, there is his wife and daughter. Except when the property is held by, please come to 3, Roman 3, my lord. Any person being an individual in the name of his spouse or in the name of any child of such individual, and consideration for such property has been provided or paid out of the known source of the individual. So whenever any property is acquired in the name of wife or child, this is excluded.
Mhm.
Except when the property is, so my lord, as far as the amended act is also concerned, to this extent, perhaps there is no problem. Now, if your lordship will kindly come to section 3. কোনটো provision এ আমাক affect কৰি আছিলে? কোনটো provision এ affect কৰি আছিলে? Huh? 24. Now, please come to section 3, Miller.
Yes.
No person shall enter into any Benami transaction. Whoever enters into Benami transaction shall be punishable with imprisonment for a term which may extend to 3 years or with fine or with both. Now, 3 is important. Whoever enters into any Benami transaction on or after the date of commencement of the Benami Transaction Prohibition Amendment Act 2016 shall, notwithstanding anything contained in subsection 2, is punishable in accordance with the provisions contained in chapter so and so. So, my lord, the amendment itself makes it very clear that the amendment which has been introduced by 2016 amendment, it will operate prospective. Now, please come to section 24, Miller. Notice and attachment of property involved in Benami transaction, where the initiating officer, on the basis of materials in his possession, has reasons to believe that any person is a Benamidar in respect of a property, he may, after recording reasons in writing, issue a notice to the person to show cause within such time as may be specified in the notice why the property should not be treated as Benami property. 3. Where initiating officer is of the opinion that the person in possession of the property held Benami may alienate the property during the period specified in the notice, he may, with previous approval of the approving authority, when ordered in writing, attach provisionally the property in the manner as may be prescribed for a period not exceeding 90 days from the date of issue of this notice under so and so. So, my lord, during this interregnum, the initiating officer has also the power to provisionally attach while issuing notice, which has been done in the instant case. But further, my lord, a coercive measure has been stayed by this honorable court. Now, precisely under section 24, the notice has been issued. So, this is the legal background, my lord. Now, our case is very simple.
Let us
There
see
is
the
a
facts.
particular will of 2011.
Okay.
Now, if your lordship will kindly come to the show cause at page 30.
This section 24 is amended or
Amended. My lord.
amended in 2016?
Yes. My lord, during the pendency of this case, a development has taken place. Earlier, there was a 3-judge decision of the Supreme Court, my lord, which has been reviewed and the matter has been asked to be gone into again by the Supreme Court. So in that view of the matter, whether we await the order of the Supreme Court, but in my humble submission, my lord, to adjudicate this issue, we may not rely upon those judgment also. But for propriety's sake, if your lordship feels, since Supreme Court has directed this, but let me first place the earlier
Then,
judgment.
Mr. Chaudhary, there is one judgment of the Supreme Court recently
That is
authored
the
by
one.
Maheshwari or
No, Ganapati Delcom Private Limited.
that
Honorable
if
Chief-
there is judgment already
Ah,
and something is pending
ah,
to be decided by the Supreme Court,
ah.
then the High Court can proceed with whatever
Okay.
whatever is there. without waiting for the outcome. That is,
Supposing there is a reference, supposing on a particular point, a subsequent bench seeks to defer. So the option available is to refer the matter.
but for the High Court,
During this pendency,
Uh.
High Court can go ahead with the
whatever is settled,
whatever is settled on that day.
exactly on that point.
Previous judgments.
But
On this point.
very recent after that,
Okay. But
within 2-3 months, last 2-3 months.
but there are
I
old judgments.
misplaced.
No, there are old judgments on that point. Also.
And after all these,
Yes.
a very recent one,
So Supreme Court has reiterated the argument.
reiterated all this, then something is pending before
No,
the,
here, my lord, there is a peculiar aspect is there. That's why I'm saying.
Okay.
I'll just place the two judgments, my lord. I go to Prospective. Ganapati welcome to Etia. If your lordship would kindly have this, my lord, you can put on it, reported. This one. It will good to assign that. It will My lord will kindly have this. My lord, we have brought the relevant portion. We haven't brought the whole thing.
earlier act is consisting of 9 sections.
Three judges.
No, this act,
Oh,
unamended, this is the only act.
Yes. Now, my lord will kindly take the judgment 2023 3 SCC.
It
315.
is there, I think, this.
Yes.
Already
Okay.
there.
I've already given, yes.
Uh,
My lord will kindly have para 127. Conclusion.
127.
Yes.
127.
Page 371.
Yes.
Section 3(2) of the unamended act is declared as unconstitutional for being manifestly arbitrary. Accordingly, section 3(2) of the Act of 16 is also unconstitutional as it is violative of Article 21 of the Constitution of India. In rem, forfeiture provision under section 5 of the unamended act prior to 2016 amendment was unconstitutional for being manifestly arbitrary. The 2016 Amendment Act was not merely procedural, rather prescribed substantive provision. Now this is important, 127.4. In rem, forfeiture provision under section 5 of 2016 Act, being punitive in nature, can only be applied prospectively and not retroactively. So this was one portion, my lord, of the previous judgment, this judgment, which was coming in our, rather to our rescue also, my lord, to additionally, my lord, bolster our case. Now, my lord, the judgment under review, it will be okay.
What about point 5?
1 second, my lord. The authorities concerned cannot initiate or continue criminal prosecution or confiscation proceeding for transaction entered into. Absolutely, my lord. This also comes to us. As a consequence of the above declaration, all such prosecution or confiscation proceedings shall stand quast. Yes, certainly, well, it will cover our case.
This notice under section 24
Yes, is only
leads
for
to confiscation
Yes.
proceedings.
leads to confiscation. Then as this court is not concerned with constitutionality of such independent forfeiture proceeding contemplated under 2016 amendment, on other grounds, the aforesaid questions are left open to be adjudicated in appropriate proceedings. The appeal is disposed of in above terms. So, my lord, there was a review filed by the Union of India, and this is the order which has been rendered in review.
Ganapati.
Same, my lord, same case, review.
Okay.
Now, my lord will kindly come to para 4. Now, para 3, my lord, earlier section 127 is quoted. 4. The court has declared section 232 of the unamended provision of the Prohibition of Benami Property Transaction Act as unconstitutional for being manifestly arbitrary and as violative of Article 21 of the Constitution. The provisions of Section 5 of the unamended Act prior to amendment of 2016 have been declared to be unconstitutional on the ground that they are manifestly arbitrary. It is not disputed that there was no challenge to the constitutional validity of the unamended provision. This is also clear from the formulation of the questions which arose for consideration before the bench in paragraph 3 of the judgment, which has been extracted above. In the submission of the parties which have been recorded in the judgment, the issue of constitutional validity was not squarely addressed. A challenge to constitutional validity of a statutory provision cannot be adjudicated upon in the absence of a lease and contest between the parties. We accordingly allow the review petition and recall the judgment dated so-and-so. Civil appeal so-and-so is stand restored to file for fresh adjudication before a bench to be nominated by the Chief Justice of India on the administrative side. Where any other proceedings have been disposed of, relying on the judgment of this court in Ganapati Delcom, liberty is granted to the aggrieved party to seek review in view of the present judgment.
Oh,
It may have, but it is in a slightly different manner.
Yes, not
It's not that there is a reference.
yes, slightly different.
That's why I thought before
it
I
is-
make my
yes,
argument
yes,
on merit,
yes,
I must
yes.
place this. I
It
think
is
in
to
all
be,
fairness, my lord, we wait.
you are having an interim order?
Yes, yes. My humble submission is, my lord, lordship will adjourn the matter sine die, giving us liberty to mention the matter when the Supreme Court decides.
Yes.
He is on legs in court number 7.
What do you say about the submission of the Legislative Council? Had it been a reference pending years?
Yes. That's why I said, my lord, it is slightly different.
It isn't set aside. But it has
Earlier
been-
judgment is no longer holding this.
No longer.
So slightly tricky situation. That's why I thought I must point out.
What is the facts otherwise?
My lord.
Just a brief.
Brief facts are, my lord, this is prior to that. In
Huh.
2011, there was a will.
Let us see the notice.
Yes. My lord, page 15, sorry, 16. Oh, notice, my lord. No, notice come to page 22.
Show
Please
cause.
come to page 29. First, this notice was issued, my lord. The operative portion is at 29.
Notice starts at page
Page 22, my lord.
22.
Therefore, page 29, the operative portion. Therefore, after considering the surrounding circumstances and applying the test of human probabilities, it is apparent that the claim about amount being her income from so-called business activities is not genuine. The claim about the amount received by Visakha Somoa and Mallika Somoa also appears to be not genuine. It cannot be said that the explanation offered by Dr. Durlabh Somoa as well as DP Srimati Deepika Somoa, my father and mother, in respect of the said amount have been rejected reasonably, and that the finding that the said amounts have been amount invested by Dr. Somoa only. You are therefore given an opportunity to show cause as to why all the 3 plots of land appearing above should not be treated as Benami property and attached as per section 24(3) of the Prohibition of Benami Property Transaction Act. MS Mallika Somoa being the considered as the Benamidar and Durlabh Somoa being the beneficial owner within the meaning of so and so, respectively, since he is a major earning member of the family, your reply should reach the undersigned on or before so and so. So this was only a show cause, my lord. Then the subsequent one at page 30 onwards, it is an show cause cum provisional attachment order
On different date. or
on
same?
different date. This is subsequent.
Okay.
The operative portion, my lord. Not there, more bhul question. Page 38, my lord. Page 38.
38. Order.
Whereas a notice under section 24(1) of the Act was issued on 6/3/20 to Srimati Mallika Somua, who is the Benamidar of the property, requiring her to show cause why said property should not be treated as Benami property within the meaning of so and so. Whereas a copy of the above notice was also given to Dulab Somua, the beneficial owner. Whereas I am of the opinion that Dulab Somua is in control of the property, may alienate the property. Now therefore, I, Sri so and so, initiating officer, do hereby provisionally attach the properties of particulars of which are mentioned below. So these are provisional attachment order. And the plot of land measuring 2 katha 17 lecha. No. 38, no. 2 katha 17 lecha.
Okay.
Our stated stand is,
Hmm.
there was a will made by the paternal grandmother. That is how this property, was Milord. And these are all in 2011 and 14.
Hmm.
So much before the amendment.
So there is a presumption.
Yes. And my lord, since
Ah.
the Supreme Court has, it may have an implication. That's why, my lord, in all fairness,
We can. This is of date.
that order in review, my lord.
1810. In November, January.
18th of October. This month, last month.
We can extend the interim order, we can
Yes.
put it in the month of January or February,
My lord.
awaiting the outcome. Heard Mr. Ken Chaudhary, learned senior counsel, assisted by Mr. R.J. Das, learned counsel for the petitioners, and M.S. M. Deka, learned counsel for the respondents. Learned counsel. Representing Mr. Esikal, standing counsel, income tax. Department for all the, for the respondent number 1 and 2. Poster. Mr. Chaudhary, learned senior counsel, appearing for the petitioner, has submitted that the earlier 3-judge decision in Union of India and another versus Ganpati DLCom Private Limited, 2023, 3 SCC 315, after review, has been recalled by an order dated 18/10/2024, passed in review within bracket civil number 359 of 2023 in civil appeal number 5783 of 2022, bracket of Union of India versus Ganpati DLCom Private Limited. Poster. And by the said order, civil appeal number 5783 2022 has been restored to file for fresh adjudication. Poster. In view of pendency of the civil appeal number 5783 para 2022 before the Honorable Supreme Court of India, let these cases be listed in the first week of February 2025. On a date to be fixed by the office, the interim order passed earlier shall continue till the next date of listing. Yes, Mr. Bikichan, that item number.
Item number 2.
Yes, Mr. Deka. Have you gone through it?
Yes, sir.
Yes.
What he's praying for the quality of the information. However, the act says only information on record. what seems to have been supplied. So,
No, thereafter he has submitted a complaint also.
yes, Lordship, but we do not have, as a commission, we do not have a power to implement our own orders.
No,
There's no provision in the RTI Act which empowers us.
see section 18. RTI. Now get up. Let us read slowly.
Yes, sir. May I, Lordship?
Hmm.
Powers and function of Information Commission. Subject to the provisions of this act, it shall be duty of
Duty.
duty.
Hmm.
Duty of the Central Information Commission or the State Information Commission, as the case may be, to receive an inquiry into a complaint from any person.
Inquire into a complaint.
Yes, Lord.
To receive an inquiry into a complaint. Inquire.
Yes, Lord.
Now let us read
Where-
E.
E. Who believes that he or she has been given incomplete, misleading, or false information under this act.
Then 2.
Where the Central Information Commission or State Information Commission, as the case may be, is satisfied that there are reasonable grounds to inquire into the matter, it may initiate an inquiry in respect thereof.
Then 3.
Central Information Commission or the State Information Commission, as the case may be, shall, while inquiring into any matter under this section, have the same power as vested in civil code while trying to suit under Code of Civil Procedure Code. In respect of the following matters, namely summoning and enforcing the attendance of persons, compel them to give oral or written evidence on oath, to produce.
To produce the documents
Yes, Lord.
or things.
Yes, Lord.
Then requiring discovery and inspection
Yes, Lord.
of documents.
Receiving evidence. on affidavit.
Requisitioning any public record,
Yes, Lord.
copies therefrom, from any court or office. Then any other matter which may be prescribed. Then subsection 4.
Notwithstanding anything inconsistent contained in any of the other act of the parliament or state legislature, as the case may be, the Central Information Commission or the State Information Commission, as the case may be, may during the inquiry of any complaint under this act, examine any record to which this act applies, which is under control of the public authority, and no such record may be withheld from it on any ground.
So I thought also earlier that after disposal of appeal, it has no power
Lordship.
to enforce
Lordship.
its order. Now there is a complaint that privacy, it appears that information is incomplete or misleading. It is for information commission to inquire.
Lordship.
It has passed an order. Come to section 19. That is appeal.
Appeal.
Now read section 20.
Section 19.
Section 19 is appeal.
Appeal.
They have already preferred.
Lordship.
You have disposed of.
Lordship.
Now come to 20. I thought that it is not there, but it is there.
20 is the penalty. Where is Central
Where the Central Information Commission,
or the State Information Commission?
as the case may be,
Yes.
at the time of deciding any complaint or appeal, means appeal is different, complaint is different.
Lordship, absolutely. The two different.
So why it shall be the duty? And what are the powers? Enforce. Subsection 3,
Subsection 3,
right?
A, B, C, D,
CPC.
E.
CPC. Order 5. Order 5 of CPC.
Order 16, Rule 1, Miller. Calling witness, attending witnesses for examination.
Order 5 is there.
Order is for issuing
And
summons. Issuing summons to the parties.
section C, section give a CPC to him.
Then, my lord,
One.
order 16.
Give a CPC to him.
CPC at the.
extra CPC নাই নেকি আমার? For a long time, I was also under the impression
Lordship, what?
that second end of it becomes functus officio.
Lordship, what, the basis of our understanding with regard to that was,
I was also.
Lordship, that one RTA will give rise to either a complaint or an appeal. So once it is give rise to a complaint, it is decided as per section 18 and penalties imposed in section 20. But once it is under section 19, initiation has been done under 19 and order is passed on appeal. They will not revert back to section 18 for a complaint.
Show me where is the
That is
provision.
not, that is the understanding we are, that is the understanding we are acting on, Lordship. Because one RTA will give rise to invoking jurisdiction under 18 or 19. It cannot invoke 19
No,
once again.
you
come back
have,
to
you
18.
decide the appeal
Because he has filed
under
an appeal.
19.
He had option
You
of filing.
decide the appeal.
Yes.
Now that has no
We pass an order under
execution
19C
power.
power. That is an appellate authority. As an appellate authority, we exercise our.
But subsequent to that, if 18 is there,
Lordship. But 18 is either one who is not getting information once filing an RTI, either he goes on 18 by filing a complaint, or he goes to section 19 by filing
may
an
not
appeal.
be correct. It
May
is
not be
not
correct.
there.
Lordship, that is the basis we are working.
It cannot be
Lordship, that needs to be looked into.
readily inferred from section 18 because some duty is imposed.
Yes, Lordship. But he comes,
Duty of the Central Information Commission, as the case may,
but once he comes
maybe
filing a complaint under section
subject to
18.
the provisions of this act. Whether any rider is there in section 19,
No rider, Lordship, but
that it is once a appeal is decided,
Lordship,
it has become functus officio in respect
No,
of
Bala,
anything.
that is not.
it's not there.
That is not there.
It is also not-
Then
Lordship, also what we
It's
worked
not-
on is that one RTI applicant, once not getting information, he either approaches the commission under section 18 or 19. Once decided in 19, if he wants to come back to section 18, that has to be looked into, Lordship. That we have not.
may not be the correct proposition.
Lordship. I appreciate.
Have you say, are you saying such thing on the basis of some authority? Any bar?
There is no bar.
If you Lordship look into 18D, as in this particular case, he opted to the provision of section 19, he has not opted to section 18B. So my lord, that has been decided under section 19.
Section 19,
But section 18B provides that who has been refused access to any information requested under this act. So he has filed a petition before the public authority. That authority has not furnished the appeal.
no,
So
here is a case, no, here is a case.
and
See,
in this particular case, my
now
lord,
in this, let us take this page 33
my lord,
as a, let us read it.
my lord, before that, my lord, if you go to the factual part also, my lord,
Wherein some information was supplied to me,
my lord, lordship can look into.
misleading and not related.
My lord, if you lordship look into my lord, the RTI petition first, page 20. Relevant parties, page 21. What is the information sought by him, my lord? That he has filed an application before the political authority, chief executive member. And for not furnishing information, he furnished the application under the SPIO, my lord. And lordship will look into page 21, last paragraph. Please transfer the petition under section 6(3) of the RTI 2005. That is his prayer. And he has submitted only application before the chief executive member, so it was transferred to another authority. So, my lord, when the transfer to the another authority, the principal secretary, office of the principal secretary replied that it was sent to the special chief conservator of forest. So he has to approach the special chief conservator of forest for his information, my lord, not to the, my lord, principal secretary or the SPO in this particular case. So the application he has filed subsequently, my lord, complain, my lord.
Mr. Sutia, then he's,
only
who is
wrong
the
and
first appeal?
misleading, not.
No, who is the first appeal?
My lord, first, if you lordship look into the, my lord, page 22.
Yes.
There as well as understand file on so and so a RTI petition by registered post addressed to State Public Information in the Office of the Karbi Anglong Autonomous Council District Karbi Anglong for seeking several information regarding the petition which is submitted on so and so date by registered post by the 7th Sakma Scheduled Tribe to demand the allotment and settlement of forest land under provisions of the land policy framed by the so and so. So that relates to the settlement of land of the particular community, the forest land, my lord. So it is required to be, my lord, conveyed to the Chief Conservator of Forest, my lord. Accordingly, it was transferred,
Come to page 28 now.
my lord. That is the interim order, my lord. The final order is that
Okay.
May 30,
And there you submitted to the jurisdiction
my lord.
without raising anything.
My lord. Then, my lord,
That has attained finality.
my lord.
This
The
part has
eight-
attained finality.
Annexure 9 finality, my lord.
Page 30,
30.
Annexure 9.
Is the final
Now let
order,
us read
my lord.
the operative
Accordingly,
part.
page 31, accordingly, the commission direct the SPIO to furnish the information to the petitioner by email registered within 10 days of receipt of this order.
Hmm.
Page 31. Accordingly, that is the order dated 6/3/2004.
Because
24,
what
my
was
lord.
the submission there?
Then, my lord, annexure 10, page 32.
See the submission there
My
of
lord.
the
Now, observation, my lord,
no, page 30.
page 30.
Because now raising this issue,
Hmm.
please see, according case will be heard against fourth, fifth para, where the
Hmm.
public
My lord.
authority will have to be present.
My lord,
Superintendent is requested to
My
ensure.
lord.
Now, in
My
his averment,
my lord.
the SPO has stated that the same petitioner has filed several RTI petitions and replies are being given in respect of some earlier cases. It is also stated this particular case and the order issued have not been brought to the notice and office was under the impression that this is the case which was being heard already replied today.
My lord.
Then observation.
But,
Then SPO at that point, along with the advocate, standing outside, prayed this commission for granting 10 days to reply to the RTI petition.
My lord.
So it was on that basis this order has been passed.
My lord. And
So
the
that
reply
is-
was punished.
That implies that you are supposed to furnish the.
My lord. My lord. Accordingly, we have, my lord, submit the reply, page 32.
Now read this along with page 21.
Page 21, my lord. If your lordship look into what is his, my lord, information he sought, my lord. One first, when did the said petition receive in the office of the chief executive member? Not any executive authority, my lord, to the political person, my lord. Karbi Anglong Autonomous Council, DIFU, what were its diary number? Second, when all this, my lord, relates to, my lord, that the petition submitted before the chief executive member, not to any officials, my lord. Then, my lord, where the petition transferred to any for, my lord. That is a vital. Where the said petition referred to and transferred to any other departments. So accordingly, the petition was transferred to other departments.
Say 6.
Supply clear photocopy of record of orders issued by the government of Assam. It is for the government of Assam, my lord, to furnish.
No, what your reply is?
My lord, we have replied the photocopy that we have that particular act, so we furnish the copy of the particular act.
Now
with it.
question is,
My lord. My
he
lord,
has made a complaint
my lord,
that misleading or incomplete.
my lord.
Now, whether any jurisdiction is vested in the state commission, because we are not going to, we are not here
My lord.
as
my
a
lord,
post office,
My
Mr.
lord.
Sutia and Mr. Sen.
My lord.
We do not exercise this power
My lord.
Absolutely,
as a post
My lord,
office.
my lord.
correct.
We see whether the statutory authority,
My lord.
Has duty.
whether vested with the power, and if vested with the power,
My lord.
whether it has acted in accordance with the statutory provisions.
My lord,
Absolutely.
That is simple.
Yes, my lord.
And whether now, as Mr. Deka has submitted, whether
My lord.
the power under 18
My lord.
is still available with the state commission or not.
My lord. Now, before that, my lord, as the case is represented by the Legal Aid Council, so the specific provision can be made before the State Information Commission that this is a petition under section 18(3) and this is the inadequate, my lord, inadequate information. There is nothing on that.
No, Mr. Sutia,
My lord.
is it really necessary?
My lord, if the general public.
Because
is
the
concerned-
commission has also
My lord, it is. if it
so
is-
much power.
Yes, my lord. If the, my lord,
Now, let us read page 34.
34, my lord, therefore.
Yes,
My last
second paragraph.
for supplying raw.
No,
and
thereafter, I have,
request only to kindly take necessary against principal secretary, my
No.
lord.
read, let us, don't
Office of
pick
the
up,
principal
don't pick up
secretary.
here and there, second paragraph.
Therefore, I have received
Thereafter, I
so
think the second paragraph is thereafter.
Thereafter, I have received.
an email
Hmm.
on so and so date and subsequently received the information via post from SPIO Office of the Principal Secretary, Karbi Anglong Autonomous Council, Diffu, so and so, wherein some information were supplied to me. Be it important to mention herein that the information that was supplied to me is misleading and not related to my RTA petition. Whether it is correct or not, that is required to be
That needs
decided
to be
by the
done.
state.
That is by the
Information
state
Board.
information. That is why, what I am saying.
That is,
We have to examine in a re-jurisdiction that whether that
yes, my lord.
authority, statutory authority is vested with a power.
My lord,
And if vested with a power, whether it has acted.
my lord, my lord. That point.
And
my lord,
that is what,
That is the law
the
point, my lord. That
question
the
is
point,
that whether the petitioner has a
my lord,
legal right
my lord,
to
Get the
file such a
information.
complaint.
my lord,
And whether there is a corresponding duty on the statutory authority
my
to
lord.
examine such complaint and thereafter pass an order either rejecting or
My lord.
allowing.
Or my lord.
For if allow,
But there is no dispute on that.
that is what
Yes.
we are on to limited question.
That comes from your lordship's mouth, not that is the case of the petitioner, my lord. That is a submission.
that
When
is
it
the-
is represented
that
by
is-
the,
that is
if the
our-
general
that-
people, my
that-
lord, submit the application before the state information, that is a different thing. But it is all along represented by the legal aid council. They are also here also, and the other, my lord, commission or my lord, in all cases, my lord, they are represented by the legal aid councils, my lord. So when the councils are, my lord, appearing, my lord, at least minimum that is required, my lord. That it is inadequate, that word is not there, only the misleading and wrong information.
My lord,
So all these things are
Because
required to be
18,
considered.
18 is laced with a condition that it will inquire into the complaint.
Yes, my lord,
And
yes,
it-
my lord.
it-
And the legal proposition, my lord,
and it is the
that another
duty,
point
my lord.
that which my learned friend submits, my lord, whether the provisions of section 18 and 19 are two distinct and different provisions.
Hmm.
If it is registered as a complaint, it is under section 18, and if it is an appeal, that is under section 19. When the order of 19 comes to the finality, then the rules provide that the rules there is provides, my lord. Then he can approve under that authority, my lord. Under the rule 2007, my lord, Assam Information Commission Management and Regulation Rules 2007. And that is the rule 14. The finality of the decision, my lord, that is.
Then thereafter, zero.
No, then the provision is there, my lord, in the act itself also, my lord. Then there is no
Rule?
appeal. Rule 14, my lord. Finality of the decision. That is under section 19. If the decision is final, then what is the remedy, my lord? Then whether you will go to the 18.3 or he can file an application for review.
Okay, finality of the decision.
Decision, my lord.
Okay.
Yes, my lord.
Then thereafter,
Then thereafter, my lord, lordship will look into the section 23, my lord,
finality of the decision.
my lord.
This is what under Assam. So
Assam Information Commission.
and
Management
appellant or
Regulation Rule
complainant may
2007.
make a application to a state user for correction of tactical mistake of fact. Then
Then there is no provisions, other provisions are there. The finality of decision, there is a provisions in that particular 14 that he may approach under rule 14 also. As it is decided by the second appeal, my lord. So
no,
he
a decision and order once pronounced by the
Yeah.
commission shall be final.
Final.
Now that has attained finality.
Then next, my lord, 2 or 3 is there. 14.2,
That is mistake of fact or mistake of law.
my lord. That the mistake of law, whether it is under 18.3 or 18E or 19, my lord, that is the mistake of law, my lord.
Mistake? No, that
No,
is.
our
mis-
case is
No.
not that we have been
I don't think
provided
this is-
I have not.
some incorrect
For
melody
correction
information.
of technical mistakes,
My lord.
okay, there is nothing. Mistakes by oversight, there is
My lord.
nothing.
My lord.
Mistake of fact or mistake of law.
My lord.
Now, what mistake of law
Mistake of law.
No,
that-
nothing, my lord.
or mistake of fact? What mistake of fact?
It is not applicable, my lord, what my learned friend has.
No,
has
what is
submitted
mistake of
to me.
fact according to you?
My lord, in the factual part, my lord, if then we have to go to the factual part, my lord.
For, that is for you to go.
That, Mr. That as we have already, my lord, the SPIO or the office of the principal secretary has already submitted the, my lord, information that transferring the petition, it is not the, my lord, like other than we have submitted the information. We inform the
No,
petition.
that has gone. That stage is gone. He's wrongly, rightly or wrongly, he has preferred an appeal, then
lord.
preferred a second appeal,
My lord.
where you submitted to the jurisdiction of the state commission and said that I will supply.
My lord.
Within
That attained finality. Now you cannot.
Lordship, and Lordship, on that point, my lord, that is my submission, Lordship may record that we have already resorted to.
Now what
section
you
6
say regarding 18? Because many petitions come and you always appear
Same,
and saying we have no power to execute.
that is a very gray area.
But if we see, suppose if 18 is applicable, then all these CPC provisions become applicable.
Yes.
And in that case, all the chapter order are available, then service of summons,
Yes.
then party for default,
Yes.
issue of warrant, all these are available.
Lordship, that is, good, but,
Now
difficulty
question is,
it?
in the present facts,
Yes.
that second appeal order attained finality. There is no issue about that.
And just
Right.
two things, Lordship. One, the Honorable Supreme Court in one of the judgments have said under section 18, the commission doesn't have power to direct the public authority to give out information because it only empowers to inquire into complaint, not to give a direction to give the information. That
While
is-
inquiring into any matter,
cannot pass a direction to the authorities to give out the information. That is one judgment will be Lordship. not
no,
concerned.
but at least
Let them
by
inquire,
that
no?
manner, it can
Yes.
impose penalty.
Penal, Lordship.
Why
now-
not?
Yes,
Where is the decision?
I'll just, that there is judgment, Lordship, that is for sure. I'll place it before your.
I doubt.
But Lordship, before that, I'll also take your Lordship to section 20. Section 20 empowers the commission to impose penalty in a complaint under section 18 or 19. So if 19 appeal was filed and the provisions for penalty was considered while deciding the appeal, and a decision was taken by the commission, now the decision was not implemented as per the petitioner to the full effect. Now the commission cannot go back and 18 and once again take the provision of 20 to impose penalty. So it will not be it will be concurrent or jurisdiction of the commission, Lordship. Because
Doubt.
one RTA application will not give rise to two penal provisions, imposition of penalty twice, Lordship.
No, no, you have not imposed anything.
No, but we have considered. They have prayed it, it was considered. So section 20 will not be considered twice in one RTR and once under an appeal, then once again going back to section 18 to impose penalty.
If both the provisions have provided for penalty,
Lordship, that is concurrent, either 18 or 19.
no,
Once
it
19
is
is done, once again going to 18 to. again
by
consider-
nothing, no provisions from 18, it is deciphered that it cannot be applied after 19.
Yes, my lord.
If the wording of.
Show me some authority otherwise,
I'll put before Lordship with regard to. the-
because penalty,
If Lordship,
let us read 20.
I'll read Lordship. Where the Central Information Commission or the State Information Commission, as the case may be, at the time of deciding any complaint or appeal, is of the opinion that Central Information, Public Information Officer or the State Public Information Officer, as the case may be, has, without any reasonable cause, refused to receive an application for information or has not furnished information within the time specified under subsection 1 of section 7, or malafidely denied the request for information or knowingly given incorrect, incomplete or misleading information or destroyed information which was subject of the request or obstructed in any manner in furnishing the information, it shall impose a penalty of 250 rupees each day till application is received or information is furnished. So however, the total amount such penalty shall not exceed 25,000 rupees.
So
So
each day till application is received or information is furnished.
absolutely, Lord. But under
So each
18 or
day,
19,
when- both.
either, Lord. Also,
Now, section 18 is duty.
yes, Lord.
Duty.
It is invoked by filing an application as a complaint.
Yes, it appears privacy. it is
They have gone in
incomplete.
appeal. Now they have come to filing a complaint of
No,
non-compliance.
where is the implementation power under section 19?
We do not have. The act doesn't.
That
say
is
so.
why
That has to be read through, and if read by
I
honorary
think
court, then
it appears to be so.
That is why section 18, my lord.
Yes, why 18 then?
There
No,
is,
that is not your case.
my lord. My lord, subsequent, my lord, application is a complaint, my lord, because after, my lord, filing appeal under section 9, which we have exhausted, my lord, there is, as per law, my lord, there is nothing left out for, my lord, appropriate remedy. Therefore, my lord, we have filed a complaint, my lord, saying that the information that has been provided to us, my lord, this is incorrect.
See, otherwise,
So, my
Mr.
lord-
Dekka, after deciding the appeal,
Lordship,
it becomes functus officio.
absolutely, Lordship.
But because of section 18, otherwise, where is the occasion? Tell me, where is the occasion to exercise the power under subsection 18 of section 3 of section 18?
Yes.
Lordship,
Now, which decision? Tell
Lordship,
me.
there is limitation to file an appeal. If an applicant fails to file an appeal, he can anytime file an, because there's no limitation prescribed under section 18.
No, Mr. I am a bit moved by the thing that each shall be the duty.
Yes, Lord. Once,
Now, once and to receive
Lord,
and inquire into a complaint from any person.
Lord,
It includes, any person includes an appellant also.
Lordship,
Any person is omnibus.
Lord,
You have received. Now, you had a duty to receive
Lord,
from any person.
Lord,
Right. And secondly, you had a duty to inquire
Lord,
into a complaint from any person, provided A, B, C, D, E, and F are fulfilled.
regard to penalty, Lord, because we cannot pass a direction as per the order of the Honorable Supreme Court. I'll place this judgment, Lord. And now, if we cannot pass this judgment, only remedy left for him or anything to do is the imposing penalty under section 20. Had we imposed the penalty under section 19 already, can the commission go back and impose penalty once again? So that is another question will come up. In this particular case, we did not
Now,
impose.
first tell me on 18.
18, once it is invoked, Lordship, the commission has the power to inquire and cause an inquiry, find out, impose penalty, exercise jurisdiction of this under CPC. But however, in this present case, can we?
That was decided not to impose any fine or penalty at the time.
Yes, this appeal.
That cannot act as a res judicata.
Lordship,
There is a different issue.
if Lordship passes an order, that will become an
Lordship, 18A, my lord, 18A, the who could not in subsection 1 of section 19 or the last line, my lord.
Let us read
My lord, who
18,
has
19.
been unable to submit request. Section 18
Lordship,
will come into
that we
play.
are missing out, Lordship.
Who has been unable to submit a request to a state public information commission. The first line, my lord.
So he has gone in first appeal.
First, my lord. So he has opted, my lord, section 19, my lord. As the case may be, either by reason no such officer has been appointed or because so and so,
Yes,
as the case may be, has refused to accept his application for information or appeal under this act. For forwarding the same to State Public Information Commission or senior.
That is not attracted in this case.
Subsection 1 of section 19 of the state, as the case may be.
Hmm.
So if he has made the request, my lord, to the State Information Commission under.
No, here, Mr. Sutia, here the judgment or order in the second appeal has attained finality. That is not an issue.
My lord.
The issue is where to go. Now, after that, whether the appellant request to obtain a copy of the record and put it on the wall, that this is a paper decree and I have no option anywhere to go. Is this the intention
No, my lord.
of this particular act? That is what I am asking.
No, my lord, no. That cannot be.
That okay, I run from pillar to post, SPIO, first appeal, second appeal, obtain an order, and thereafter bind it and put it in the wall. Because State Information Commission has no order, no power to implement its order, even if some allegation is there. So, and High Court will see, and High Court will become the executing court. That he will come running to the High Court in 226, and High Court will assume the power of an executing court, of a decree of a statutory authority. Is this the intention?
It wasn't. And in fact, Lordship, the State Information.
Oh,
Commission
because
has-
from your submission, it appears.
we have no, till now, we have no authority to hold on to act against a non-compliance order.
Huh?
No authority in our hands from any court which has fallen into our hands.
No, here is a case of complaint.
Absolutely, but that interpretation, as I submitted before, Lordship, basis was 18 and 19 are concurrent. 119 he has availed, will now not go back to 18.
Okay.
That was the basis we had.
You make the inquiry, take out, so that I should not be wrong also.
Lordship,
Okay, we'll take out after some time, you just,
in fact, a rule was
if it is a Supreme Court judgment,
not to pass direction only with regard to under
Huh?
section, not to pass any direction to supply information under section 18, the judgment, crux of the judgment. I'll place it before you, Lordship.
please,
And Lordship,
Supreme, it will be easily available then.
Lordship,
If such is the observation of the Supreme Court, Maybe-
I don't think, my lord.
I also don't think.
My lord,
Yes,
my
But
lord,
since
my
he has said,
not
My
to pass
lord.
direction.
I
Well,
also
cannot-
prima facie don't think,
lord,
but still Mr. Deka is saying,
my lord,
we have to respect his submission.
let us
Lordship, I'll
see-
just place it before.
Okay,
yes, my lord,
because
let-
this is
Fix it.
taking time, because
Submission.
otherwise many writ petitions, Mr. Sutia, I am taking interest in this case because many writ petitions are being filed here, unnecessarily burdening.
In this particular case, my lord, regarding this information, another repetition was filed for non-furnished.
My lord, your lordship is,
We are not going to do that.
your lordship
We
is
are only-
pointed out a core issue, my lord.
If find out no decision, I'll go through it.
Lordship will take it
Otherwise,
today, or Lordship will take it any other day.
you,
then-
you find out the decision by Googling it.
I'll just submit.
Tell me, I'll have a glance, then put it on another day.
I'll just submit.
Thursday, my lord, Thursday.
We wait for some time, let him say, is it really the direction?
Yes, yes,
Then our hands might be tied.
The point is here, 18, E, my lord, 18(1)(e) and section 19, whether these are the two concurrent provisions or the separate provisions. So
Whether,
that
whether, my
the
lord,
complaint
Supreme
can-
Court has said that it is concurrent.
Let him,
My
let him,
lord, my lord,
let him, let him.
yes.
I'll just.
You have not done anything.
Let us.
You have not assisted the court. It is court who is
Yes, my lord.
assisting himself,
Yes, my lord. Yes,
itself.
my lord.
You are not saying anything.
I'm.
You simply come with a complaint.
I am deeply obliged, my lord,
You
that your
simply,
lordship has.
you have come crying, said that my complaint was not taken into cognizance. That is all you have submitted.
But your
It
lordship
is
has
the
taken-
court who is taking
My
pain
lord,
to
my
find
lord, I
out.
am deeply obliged, my lord. I am deeply obliged. And it will resolve, my lord, many issues in coming into the.
Because
court.
I am finding many repetitions, Mr. Sutia, are being filed here.
Yes, my lord. Your lordship is correct.
Regarding that.
And for
Yes.
this point, my lord, if it is resolved, my lord,
It's right, my lord. My submission, my lord. 18 is a different, my lord, procedure and the 19 is a different procedure. But that submission that Mr. Study Council made there, whether it can be moved to the
Yes.
19. But if it is the one 18E, if it is not as adequate, then definitely.
Why not?
yes, my lord.
Inadequacy, my lord. But not in this particular case, but in the.
Then what will be the forum otherwise, Mr. Sutia? For the High Court? High Court? No.
High Court, but not the executive court, it is the right pilot. 18E is the separate provisions, if it is not the furnishing the information, they can inquire it, pilot.
Yes.
Regarding inquiry, after inquiry again, pilot penalty provisions, then it will come. Under
Yes.
18, my lord, not 19 is a different provision.
Yes.
Obliged, my lord.
Let Deka come up with the decision. Okay, it will let you. এই কাগজটো নাই। What is the main writ petition? 7.
7, my lord.
And what are the other?
Other is subsequent writ petition when the, my lord, order, the committee was dissolved, my lord, that was has been challenged. That was.
Consequential order.
Yes, my lord.
Cooperative society. Cooperative societies, right?
The order impugned is at page 48, another 13.
1 minute.
Into Suppression nearby chemical.
Page.
Page 48, another 13. The secretary has, the respondent for was the secretary, he was removed from service and he has filed an appeal against the removal order, that is.
No, page 30 is appointment.
Oh, yes, my lord.
Page 30 is appointment. Is it not?
Yes, my lord, page 30. Yes,
Huh?
yes, my lord. 30 is appointment.
30.
30 is appointment.
Appointment of respondent number 4.
4.
Okay.
Yes, my lord.
Then
my lord, he has been removed. He did not join.
which page? Which page?
That he has been removed from the post of secretary by resolution. There
Page
is page
75.
page 35. And
I have,
the
I have,
resolution.
I have noted down the page. 75 it says. 75. Page 30 is the appointment order.
Yes.
Then 75 is a board meeting. I mean, don't we have a
In
news?
the writ petition, board meeting is 35. 35 is the board meeting. Page 35.
No,
That's it, 75 is also a board meeting resolution.
That is
9. That is what I am saying.
that is running, my lord.
No.
He has
They have
placed
noted
an
all
appointment in the
75
resolution of
has been
70.
appointed.
Yes.
That is also recorded in the board meeting.
Yes. 7th.
7th. Okay. Then page 31. Page 31. Some complaint was received.
Yes, complaint received.
Then page 31, it was sent to the journal register.
Journal joint registrar. Yes.
Something like that.
Yes, my lord. There page 31 is his letter, my lord. That some complaint has been received against the.
This is the complaint. Page 32 is the complaint.
32 is the complaint.
Okay. Page 32 complaint. Page 32 is the complaint on 27/10/2021.
Yes, my lord.
Then it was sent to the chairman on 1st November, page 31.
Yes, my lord.
Okay. Then page 35.
Yes, my lord. The board resolution taken, page 35.
Page 35. something. Cancel.
Yes, my lord. Appointment
Where is
cancelled.
that resolution?
Resolution is page 7, yeah, another 7, page 35. By resolution number 1.
Seva Shakti Club, so and so direct. Should be cancelled. Cancelled. And steps may be taken up. Okay.
Then 39 is the
One.
order communicated about cancellation of
38.
appointment. Yes.
And
Then he has filed an appeal.
1 minute. That
Appeal, we did not,
that
but in the
one
affidavit we got it.
39. He has been informed, page 39,
Yes,
that your appointment has been cancelled.
cancelled.
Then there is an advertisement.
Advertisement for subsequent consideration
Appointment.
of appointment of secretary.
Then 42. Some FIR was lodged.
FIR laws that he has manipulated the record.
Okay. Then 45.
45 notice for
Petition
hearing of the
5.
appeal.
This is
This is notice for hearing of the appeal. Man. Then impugn order has been passed.
14/22. This is notice.
Yes.
Forty-nine to B.
L.
Huh?
49 to L.
That is what I think Mr. Talukdar was asked to address. That is what Mr. Talukdar was asked to address. 49 to L. Whether register is vested with the jurisdiction to decide any employment issue between the chief executive and the board under 49 to L.
It will boil down to that point, whether the register had the authority and jurisdiction to pass this one.
That is what?
Yes.
And that to decide that whether 49 to L incorporates or say is implicit therein that matter of appointment and cancellation of appointment can be dealt with by the register.
If I put it in this way,
48. Okay, let me register treated the petition as 49 to L against cancellation treated. Where is the order? Impugn order.
Yes, impugn order is at page 48.
How many board members were there at that time?
6 members.
Total.
Yes, total 9 members.
And meeting was held by
by that 6 members
6 out of 9.
out of 9.
Yes.
So in the impugn order, my lord, your lordship may kindly look that some mistakes also committed by the registrar while passing the order. That your lordship will find the two, my lord, serial number 2 in the impugn order, the last paragraph. Only 6 members have signed in the resolution of the board of director meeting held on 7/10/21, which is sort of requisite quorum 8 members of the board of directors as required under section 43(5) of the Assam Cooperative Societies Act. Now here, my lord, your lordship, this meeting held on 7/10/21, that is also wrong. Actually, board meeting was held on 1/10/21.
110.
1/10/21.
Or is it part of this record?
Yes, ma'am, that board meeting, that page 35. Board meeting was held on 1/12/21.
112.
Yes, page 35. In the top, my lord, place office of the society, time, so and so, date 1/12/21. And 7/10/21, the board meeting was held for his appointment.
Okay,
There is
110.
a
Okay, factual error.
yes, factual error, man.
110. Okay, page 35.
Page 35 is 1/12/21, the
112.
1/12.
110 or 112?
1/12. That 7/10 is the appointment, board meeting held for appointment. And 1/12 is the board meeting held for cancellation of appointment. These are
710.
Seven-
710 is the
yes,
meeting.
yeah, a board meeting held for appointment of respondent 4.
Where is the meeting? Where is the meeting?
Yes, page 26, my lord. Page 26 of the writ petition.
Okay.
Page 26,
Okay,
proceeding of
26.
so and so, the top 7/10/21 and members present 9.
Okay, board meeting.
Yes.
Okay, board meeting 710. Okay. 9 members.
9 members
Ah,
during his appointment. Then again, board meeting on 1/12, that is page 35.
That is cancellation.
There is cancellation. Now, registrar has committed a mistake here, that he has, in finding the para 2 of page 48, annexure 13. Annexure 13, only 6 members have signed in the resolution of the board of director meeting held on 7/10/12, which is sort of, so it is not 7/10. There is a mistake. So he's finding he has 7/10/12.
It should be what?
It should be 1/12. 1/12/21.
Yes.
So by treating that, my lord, the impugn order has been passed. In that count also, the impugn order, my lord, is not
What is the quorum?
correct. Quorum, my lord, you are 43/5, my lord.
43.5.
(43)(5). The quorum for a meeting of the board shall be such as may be specified in the bylaws, but shall not be less than 50% of the total member of directors of the board. So out of 9, 6 members were present. So, my lord, the board meeting was correct, my lord, as per the 43.5. Now, there is requisite quorum of that 8 members, whatever the registrar has held. It is before amendment. The amendment was there. that in the before amendment, there should be not less than 8 members. But after amendment, there is no, my lord, the only the total members may be increased to 21, but below, my lord, there is no such mention in that.
Where is that composition of the board?
Yes, my lord, that is your lordship will find 35.
Section 35?
Section 35. Earlier, it was before amendment, there was 15 members and minimum members of board meeting was 8 earlier.
No, when?
That is
Amendment when?
my lord, your lordship will find the bottom, my lord, insert a new substance, so respectively.
That is in 2015, 13.
No, in the, my lord, in the substituted for the words 15 members, the down below, your lordship will find. Substituted the words 15 members of directors by the Assam Act of so and so, so and so, so and so, dated so and so. So this has been amended, my lord, inserted, that is 2035 clause 2 is replaced. Then minimum 8 members has been replaced.
Minimum 15 has been replaced.
Yeah, minimum 15 is replaced. Even that, my lord, that provision has been replaced. It was enhanced to 21 and no, my lord, the
Lower limit.
lower limit.
Maximum 21.
21. Section 35(2).
35(2).
Yes, ma'am.
Amended in 2019.
19.
Maximum. Otherwise, how many, what is the strength of your?
Now it is 9. We were 9 and 3 were absent on the day of holding the meeting.
That was the total number.
Yeah, total number was 9. This committee was having only 9 members.
9 members.
Yeah, out of, well, when it was constituted, there was 15 was the highest number. In the 2019, it was amended. So maximum was gone to 21. Then they can co-opt members, 2-3 more members. The board may co-opt. But they did not do before this board meeting. They did not do. Later on, they have done it.
So on that day, during that period, there were 9 members.
9 members.
In
And
the board of directors.
yeah, 9 board of directors. That whatever they in the board meeting during appointment of secretary, that was the total member of the board.
And what is the bylaw regarding quorum?
Bylaws, my lord,
Quorum for the meeting shall be such as may be specified, but shall not be less than 50%.
bylaw was actually, this bylaw was after amendment, no new bylaws have come.
Okay.
Yeah. So there's earlier bylaws that 15 and minimum is 8. That was there. Maximum is 15, minimum is 8. Earlier bylaw. After amendment, no bylaw, my lord, has come.
So
So by means of this 6%,
that
they have,
order, impugn order,
yes.
by the impugn order, that respondent number 4, his order of cancellation has been set aside.
Challenge.
And you are agreed by that.
Agreed by that. Because it was directed that your lordship, the last part your lordship find. Do hereby set as, that is the last part 48A. Page 48A. Now thereof I Shri so and so, Registrar of Court Society Assam in excess power 42L of Assam Court Society do hereby set aside the advertisement. He has also set aside the advertisement and allow the opposite to continue as the secretary. This is the impugn order. Advertisement was set aside.
So this order is bad for what?
My lord,
Because he is saying 49(2)L.
there is no dispute, my lord, of this, this 49(2)L was, my lord, a dispute between the society and
Board.
yeah. In case of dispute between chief executive secretary and the board in any manner, no such dispute was there. The decision of the registrar shall be binding on the board. It cannot be a dispute because he did not even join. Our case was that secretary, though he was appointed, but he even did not even join in the post. In the resolution number of the board meeting held on 1/12/21, resolution number 2 was said that since he did not join, the resolution was there. But respondent board did not challenge it also. Such resolution adopted by the board was not challenged by the secretary till date. And in exercise of power 111, your lordship will find, except where otherwise expressly provided to the contrary, an appeal shall lie to the registrar from the decisions made under this act or rules framed thereunder by any government officer.
Board is not government officer.
No, board is not a government officer. And also section 92, your earlier hearing, your lordship has considered that.
Yes.
92 also is a disciplinary action. 92,
It is accepted.
any dispute touching the business of a registered society, other than dispute regarding disciplinary action taken by society or any liquidated society shall be referred to the registered so and so, so and so, so. And he did not join, my lord, that your lordship may kindly look into his affidavit in opposition, first affidavit in opposition, my lord, what he has filed. Page 9.
Running page, any idea?
No, man, running, sorry, my lord.
Affidavit in opposition by?
Opposition by filed with the respondent number 4.
Okay. Yes, paragraph?
Yes, no, but the annexer, my lord.
Annexer.
Annexer be page 9. The lordship will find to the chairman, Bikrampur Court Society, so and so, subject joining report. Dear sir, I have the honor to inform you that I have joined
Annexer D.
Yeah, Annexer B.
Annexer D.
Page
Is it
9.
notice? Annexer B or D?
B, my lord.
Okay, B.
First, he has first affidavit in opposition filed by respondent 4. First one, my lord. The annexer B, page 9.
Yes. I have joined.
Yeah, joining report, that application of joining addressed to the chairman, your lordship will find. Now, the down below your lordship will find receipt and so that the office of the Asian Registrar of Cooperative Society, ARCS. Well, he did not join, but now he says that I have joined. No such copies we have received. I have also stated in the retribution also that he never joined. Even resolution number 2 also adopted in this regard by the board that he did not join. Then his, my lord, appeal, your lordship will find in the same affidavit in the page 12.
He said, I have joined.
Yes, my lord, there. But he has said, that's, I have been appointed secretary of so and so, as per resolution number 1, so and so, 7/10/21, board of directors, so and so. Accordingly, I have joined on 8/10/21, addressed to the chairman of the said society with copy to the ARCS, so and held the board meeting, so and so. That's why FIR has been filed. The board meeting, when he has manipulated the record, my lord. That's why FIR has been filed. Where from he got that proceeding book? On 8/10 he has 8/10 he joined. 9/10 he held a meeting. And that proceeding book, your that he has manipulated the record. For that FIR has been filed. Then the another thing, clause 3, he did not join in pursuance of any joining report as is directed. The Sri Sanjoy Kumar Barna on leave, senior inspector of society who holds the charge of secretary of Victim Society. So to hand over the charge, he was not handed over the charge. This is the departmental secretary earlier, my lord, before him. Sanjoy Kumar Burman was the departmental secretary. He was withdrawn from the charge. Thereafter, this respondent number 4 was appointed. So
Now come to page
Yes.
that impugn order,
yes, my lord.
because two reasons have been assigned. One is the petitioner who has been removed from the post of secretary was not given prior notice for his removal,
Yes, my lord.
nor he was given any chance for his defense.
Defense.
That is one ground.
Yes, my lord.
Second ground, only 6 members have signed the
Yes, my lord.
resolution
Yes, my lord.
in sort of requisite quorum
requisite
of
quorum.
8 numbers
Yeah.
under section 43(5). About 43(5), we have said that 9 members or 6 would be quorum.
Yes.
So far, removed from the post of secretary without any prior notice for his removal.
There is a law does not provide, my lord. He's an employee, employee of the society, my lord. This 49, my lord, 49,
Now, because he should not be given any
no, my lord.
prior notice.
Not necessary, my lord.
Every day, Mr. Sinha is coming with petitions, no prior notice.
My lord, here the prior notice, he did not even join. He even did not even join. He did
That
not
is a
start.
disputed question. Let us resume for a moment. Let us resume for a moment.
Yes, my lord.
Let us, he has joined.
But he's a mere employee, my lord. Employee, the board has that power, my lord. They have exercised that power.
But why? Otherwise, any government employee, if it is to be removed, it is to be removed by prior notice.
Yes, my lord.
Why separate?
No, here, my lord, the law is, my lord, framed in such a way, 38(2), to nominate, elect, or appoint and remove the chief executive. He is not a government employee, provided he is not a government.
Everywhere the principle of natural justice is incorporated. Whenever a person is to be visited with adverse consequence, that law reads the principle of natural justice into it.
Private, my lord, private employee. Private, my private.
Is he not entitled?
I don't think so, my lord. In this case, I am the owner of the, I am the landlord, my lord. I may remove my servant.
Oh, what is called? What it is called? Yes.
Please, your lordship. Lordship,
Otherwise, this society is not a state under Article 12. Now, on that basis, whether the society is a state, this society, Bikrambur,
lordship,
under Article 12.
I'd like to lordship start from the beginning, lordship. Otherwise, I might lose that trail of meaning.
Okay, Mr. Singh.
Yes, ma'am.
May come to page 75. Just to counter one argument that he has not joined. Page 75. Lordship, till this point of time, management has not filed any affidavit to say that this is entirely false document. Page 75 is a false document. That should have been his yes, because someone filed such a long false report, obviously should be penalized by law. It should not have spread that.
Otherwise, Mr. Goswami will proceed on the basis that he has joined.
No, lordship, my under corollary submission is that they have this petition has been filed and founded on entirely false facts, lordship.
Okay,
On this ground alone, lordship, he has approached the High Court with unclean hands, lordship.
Okay,
This,
otherwise,
Page 75 lordship will make it very clear that the entire submissions are wrong.
Mr. Goswami, otherwise, court would like to proceed that after the appointment, the respondent number 4 has joined. And thereafter his appointment is cancelled.
Yes,
Without going into all these facts.
yes. But I.
These are disputed.
I'll go into that.
Now-
That's it.
Okay, you go.
But
but-
I'd like to make this.
But
as my
unnecessary
first
things
submission.
are not to be
First
submitted.
petition is a petition founded on false submissions. First, I'm very clear, very sure I'll Lordship point it out. Second part, Lordship, as regards the quorum, Lordship, I'll come one by one, the quorum. The quorum refers to the bylaws. If the bylaws have not been amended, this existing bylaw would be irrelevant. Lordship.
It was,
Because the registrar on that day, when he passed the order, he was under the belief they have been acting for under the minimum quorum should be 8.
the question, very first question is, Mr. You have going down again top. Very first question is, what is challenge is legality and validity of the the assuming jurisdiction by the registrar.
That part, yes, I have.
That part you have to address.
Lordship, then.
Whether under 49 2L
49(2),
or 111, that power is available.
Lordship, that applies to any order passed by any government officer.
No, so apparently not.
No, 111 would not apply.
So he has misquoted a wrong
Misquoted.
provision. But that does not mean
Yeah.
if the power is otherwise available to him.
Yes, yes.
So proceed on that
Mr.
basis.
Lordship, the respondent had applied under 49(2L).
2L, that is what,
And this has been decided on 49(2L).
okay.
Only that somehow it was admitted erroneously that particular provision.
Okay, 49 2L, whether power exists there.
My understanding, it exists, Lordship. In case of dispute between the 2L, it says between the chief executive and the board in any manner, the decision of the registrar shall be binding on both. This is a dispute, not necessarily a disciplinary dispute, Lordship. Because Lordship, once this appointment or joining is taken to be a given, Lordship, that is he has joined. Then Lordship, if he has to be removed, then there has to be a disciplinary proceeding, disciplinary action. That has not started. If that has not started, how can he be heard, Lordship? This appears to be entirely arbitrary action on any, whether state or semi-state or any person in authority.
No,
Has to
no,
be
that is why I have put the question. State. This is a question. Secondly, whether this kind of immunity, the immunity enjoyed under Article 309 is available to you. Right? Or if 12 is there, then Article 14, 16 will come and 309 will come. 12 is fundamental right. Part 3. So I don't think you are a state. That society is a state. So Article 12 will not come. Now what will come? Otherwise, it is a contract of procedural service. It is akin to a company, say, private limited company. Bajaj Insurance, say,
Yes.
and an employee is terminated by the board of directors. What is the remedy? Is there any writ petition
No.
in this court?
I'll not do.
No.
I'll not equate the cooperative society with that. Lordship.
No, but
Because,
that is not a state.
This and cooperatives have to act within the framework of the Lordship Act.
Sure, sure.
So can't there
Then
be at least
has the law in 1976? Yes, Mr. Talukdar, what is that college? What is that college? Lakshmi something. That is, I think, still holding the field after 50 years. Yes, a society or a company. It is, a society is incorporated under the provisions of the statute.
Yes, sir.
So it has to follow the provisions. But that does not mean that it becomes a state or any instrumentalities of the state. So it does not come under section 12,
Yes, sir. I do
Article
try
12.
that, yeah.
Lakshmi Narayan or something like that. Voice Degree College? Option, Voice Degree College, VAISH. And that has been upheld by everywhere. So that also does not enter. Now question is, it is a case of volition. It appears to be a contract of personal service. Then it comes Specific Relief Act 14(1)(e) and 14(1)(e) perhaps, or 14(1)(b) specifically. Then no court will injunct. And the remedy is damage. So whether this register that will be addressed by Mr. Talukdar under section 111 or 49(2)(l) has the power to decide on it. Other factual details we are not going into. Well, simply that you have been appointed. I am dealing the issue in your favor, that you had been appointed. And you joined.
That will also finally at the end of it benefit the petitioners because this person will be.
We
out
are
of the
not
system.
here to decide whose benefit it will going to pass.
But
We are
if I find-
testing the validity of the order.
Because even by approaching the court with unclean hands, lots of with false facts.
What
can they
unclean
be
hand?
allowed to
What
succeed?
unclean hand?
Lordship, this person is joined. Lordship may see the report, Lordship, page 75. Lordship will make it very clear. Their whole issue is that he has not joined. Entirely, he has not joined. He has joined. That is where the falsification of facts have come. Lordship.
Okay. Suppression.
As regards the decisions, Lordship, that is, I have to come back to you, Lordship.
No, we are not coming back. We are closing it.
That way,
Yes, Mr. Talukdar. Anything more? You can supplement thereafter. Joint. Anything more? Yes, Mr. Talukdar.
as you the quorum part only, Lordship. Quorum, Lordship, I think they are going with a prevailing bylaws until and unless it is replaced. Otherwise, it will be a chaos if that particular bylaw is not followed.
Quorum. Prevailing bylaws. Yes. Any contrary judgment of any coordinate bench?
There is a judgment.
Because you are a standing counsel corporation
correct.
department.
My lord, there is a judgment of court number 5, Honorable Justice my lord Shyam, that writ petition was allowed. And my lord, on the appeal filed by the board, the Honorable Division Bench, my lord, has stayed the order. But in that case, I think, my lord, the resolution of the board was under challenge. So therefore, the Honorable Division Bench has held that it lies within the realm of contract. But here, case is slightly different because the registrar is intervened.
Here the order is of the register.
Yes, my lord.
We are testing the
Order of the registrar.
register, validity of the.
Now-
And if that is accepted, then consequently that board
Yes.
cannot so on its own
Yes.
remove a secretary.
Yes.
The question is, we are not going into deep into it, but question is 111, 49, 2L.
Well,
These are the only thing.
yes. In fact, my lord, my first respectful submission is,
What about 111?
my lord, 111 apparently not applicable because 111 says that appeal is maintainable against the order of the government officer rather than my lord subordinate officer. So here there is no order of subordinate officer. So therefore, exercise under 111, my lord is not maintainable.
Okay.
But as your lordship has said, my lord, that which has fallen from your lordships, that irrespective of reference of a wrong, my lord, provision will not invalidate the order.
Yes.
So if I, my lord, am able to show that there is a source of power
Yes.
under the facts of the case, my lord, if your lordship is satisfied, then perhaps, my lord, the impugned order sustains. Now, what I find from the, my lord, writ petition, the order, my lord, is not challenged under 49(2)L. So that aspect, my lord, may be kept open. In an appropriate case, your lordship will decide whether 49(2)L gives the registrar, my lord, the power to decide an issue with respect to the disciplinary authority. Specifically, the pleadings is absent. But I am not harping on 49(2)L.
No, whether this is said or not, that without
I
any
did not
power,
find-
without any
My
power,
lordship-
authority and jurisdiction.
Because the jurisdiction part, my lord, is perhaps absent, my lord, in the writ petition. The order is not challenged, my lord, for lack of jurisdiction, my lord. My lord,
Being not maintained, it is there. Disposing of the same as an appeal being not maintainable in law
Yes, ma'am, it's there, ma'am.
and to continue to work in the post of
Yes.
secretary.
There are 8, ma'am.
Because power of reinstatement, that is challenged.
correct,
And also an appeal being not maintainable in law. That is law point. We are on law point only, 49(2)L.
my lord, I am trying to draw your.
Colorable exercise of power.
These-
It is there.
These are vague statements made, my lord, but when he challenges 49(2)L, he has to at least describe or narrate, my lord, his understanding or the perspective on what ground, my lord, it is not maintainable. Absolutely, there are no such statements, but I leave it to your lordship, my lord, because I am taking your lordships to section 92. Under the facts, my lord, I respectfully submit that the registrar reserves his power under the fact to pass this particular order.
So your argument is, Mr. Goswami's argument is 49(2)L.
My respectful submission would be your
Your-
lordship will keep open, my lord, that particular aspect in appropriate case, 49(2)L. Because that is specifically not under challenge. That the registrar does not have the power under 49(2)L to pass the impugned order. That ground is not taken. In appropriate case, your lordship may, my lord, decide. If your
No,
lordship.
if we go to 1492, we have to go to 49(2)L because that is mentioned in the order.
I leave it to your lordship. But here
I
92
am
says,
taking your submission as regards wrong quoting and traceable to 92.
fine, correct. So it says, my lord, any dispute touching the business of a registered society other than a dispute regarding disciplinary action taken by a society against an employee of the society. Now this exception has been carved out. Disciplinary action, my lord, cannot be, my lord, a reference of dispute. Now my respectful submission is, the registrar having found that the dispute in the present case touching the business of a registered society, because the secretary, my lord, is the
my lord, the person who conducts the day-to-day business. So therefore, if this issue is not resolved, then it is amounting to touch the business of a registered society. So secondly, my lord, what the register found, that this is not a case of disciplinary action, because under the rules, a disciplinary action has to proceed by a show cause or by some procedure.
Rule?
My lord, there is a rule of the government, my lord, but
Right.
albeit that rule has come afterwards.
And
Yes, but the principle has to be
when
applied.
it is not in the domain,
No.
when it was not in existence,
My lord.
when this action was taken,
Yes.
the rule cannot be otherwise. The statute is not providing, rule cannot have prospective, retrospective.
Correct, my lord. What I find, that the register, my lord, had issued an order, my lord, asking all the societies to adopt this rule, where there is no existing one. So my learned friend would be, my lord, the best person to say whether the rule relating to appointment, removal of secretary was in vogue or not. And
When it was issued.
it was issued in 23, if your lordship see.
We are into,
No, what I'm trying to say, already, my lord, they might have a rule. The society.
no.
No.
The thing, it is an event.
No, what I'm trying to say, this rule will come into, my lord, effect in respect of all the societies where there are no existing one. This rule says, the register is aware of the fact that already the societies, they have their own rule. So if the present society have a rule, that rule will, my lord, definitely apply in the present case. And that rule will be
See, we
inconsistent.
cannot go on like this. Rules are there or not, we don't know.
My lord, my submission is, so far as the principle relating to
Because
removal,
register is not referring to any rules.
register is not referring to rule. What I'm trying to say, my lord, these are general principles. My lord,
I understand. That
yes.
is why I am asking repeatedly to Mr. Goswami, again to you.
Yes.
Suppose
Yes, correct.
this, are you known to contract of personal service? Contract of personal service.
Well,
Or section 14? That has been repeatedly referred to all in all the judgments. Contracts not specifically enforceable. Following contracts cannot be specifically enforced. Firstly, some amendments recently. Otherwise, injunction when refused. An injunction cannot be granted to prevent the breach of a contract, the performance of which would not be specifically enforced. Now here, section 14 comes into picture, that is 41. Contract not specifically enforced. A contract which in its very nature determinable. This is a contract of personal service. Once, because it is not a contract of employment. Contract of that one party can continue get the service till he is satisfied.
No, that is correct, my lord. This is, so far as the board is concerned, resolution will apply. But
Now
what I'm
till-
trying to say, the
Hmm.
register has exercised in power.
Hmm.
Now the question is, my lord, the exception has been carved out,
92.
92.
Okay.
Now this particular order, whether it will fall under the exception or not,
Okay.
if it does not fall,
Okay.
then my lord, my humble submission is the impugn order will sustain. Now, my lord, it says, other than a dispute regarding disciplinary action.
Now in, my lord, normal parlance, my lord, we understand that the disciplinary action to essentially precede by a, my lord, show cause or an inquiry. And the registrar has, my lord, observed in his order absolutely nothing, no show cause, no defense. So therefore, my lord, the registrar has understood that this is not a, my lord, case which falls within the realm of disciplinary action. So in that view of the matter, my respectful submission, my lord, that the jurisdiction exercised by the registrar, my lord, is traceable under the act. And so far as, my lord, the quorum is concerned, the registrar has rightly pointed out, my lord, the submission of my learned friend may not be correct. Because if we reduce the quorum, as per his submissions, my lord, that if the, my lord, total members are 9 or 6, my lord, then there may not be, at some point of time, then there may not be quorum. 1 or 2%, they may take a decision against the entire society. So it has to be understood that the quorum is relatable to the total strength of the board. Normally, my lord, throughout the Assam, 15 members, my lord, are the total strength.
No, that has been changed. There is no minimum.
No, my lord, if your lordship goes by 43.5, lordship has to give, my lord, some importance to the bylaw. 43.5 makes it clear that one has to go by the bylaw. And bylaw will come in, my lord. Bylaw says 8. 43.5. 8 will prevail. In any case, my lord. There were 9 members. My lord, the presence of 8 is mandatory. If you want to, my lord, take through, my lord, the motion or the resolution. Subject to your lordship's acceptability, I am submitting this, my lord, making this argument. This is what, my lord, I want to say.
Leave it to the lordship. Leave it to the lordship. Bylaw, well, only the bylaw is superseded by the act. It is the act itself says, my lord. The 43.8, 43.5, whatever says, the quorum for a meeting of the board shall be such as maybe specified in the bylaw. But no, there is a, my lord, the emphasize, but shall not be less than 50% of the total member of that. There is the act says. So, my lord, he overruled the bylaws, my lord. And also section 9.3. Section 9.3 my bylaws, about the bylaws, what the law says, this act says, my lord. Section 9.3.
9.3 of what?
Of Cooperative Act, my lord.
9.3.
9.3. About bylaws, my lord, whatever the act says, my lord. May I read? The bylaws may contain such matters as decided by the General Assembly and shall be specific and confined only to the matters provided in the Schedule B. However, the bylaws of a society shall in no case supersede the provision of the Act. In no case supersede the provision of the Act.
Where is the conflict herein and where is the supersession?
No, supersession.
No, we don't know about the total number of members.
There is, my lord. And my lord.
He says 9. He says 9. And no contrary submission.
The total number of
No,
members.
you have said 15.
No, it has to be understood in terms of the notification of the AGM election. Those are notified. 15 numbers, my lord. Now, suppose, understanding, but suppose, my lord, there are 10, my lord, nominations. But that will not mean, my lord, that there are total 10 members. This 10 has to be understood in terms of the notification issued by the, my lord, secretary or the board, my lord. In across Assam.
Has he traversed anybody? Have you filed any affidavit?
My lord, no, this is my lord, I am submitting before your lordship that this is the, my lord, actual state of affairs. But the submission made by my learned friend, if that is accepted, that will be a wrong proposition, my lord.
No. At that time, there were 9 directors. That is what his case is. If I have understood correctly.
Yes, ma'am.
And 6 held a meeting. Okay, that is his case. His submission. Now, your case is that ordinarily a board have the strength of 15.
Notifications are issued for, my lord, election of 15 members.
Yes.
Yes.
Then this provision has been changed in the meantime. Statutory provision.
Yes.
In the meantime, prior to this situation, and where it provided that maximum, no minimum, no minimum,
Maximum.
maximum 21. That situation has changed.
Yes.
And we don't know, there were the provision composition should have 15 notification. But add on the date, that is not controverted by the respondent number 4 also, that it had strength of 9 and 6 took the resolution. Though at the time of appointment, it was about 9. Now, I have understood your submission.
No, Malot, what I'm anxious about, Malot, if this proposition is accepted, then the consequence would be, Malot, very, Malot, what I say, it will have a very, Malot, bad effect. Because if the total number is not considered, qua, Malot, the total, Malot, the members which is indicated in the notification.
That is also a dangerous situation. Suppose because of death or whatever, 15 out of 15, 9 remained. Now, then say it is according to statutory provision, it is 8. Suppose your submission is accepted. Out of 9, 8 is the quorum then.
Well,
And situation may also happen.
no, in both
That,
sides, Malot, but
both
the
sides have to see.
cascading effect, Malot, will have on the society if, Malot, it is understood that on the date of, Malot, counting the quorum, the members who are present, that is the total members. If that is accepted, it will have a cascading effect.
There are various interpretations to it. I have understood your submission. That's regarding quorum.
And regarding, Malot, the application of the bylaw, when the bylaw says that 50% of the total or minimum 8, then minimum, Malot, will apply in the present case. Because 43(5) says in terms of the bylaw or 50% of the total members.
There are many interpretations of this kind of provision
No, but
everywhere.
absolutely. Malot, what I'm trying to say, it's a matter of
Total
interpretation.
number of members. Okay,
No, sir,
I have understood.
no, sir, I just have one response. No, sir, there is no conflict between the wordings of 43(5) and bylaw. It in both, lordship, the maximum number of directors is not specified. It only refers to a particular percentage list without referring to the numbers. Because 43(5) says the quorum for a meeting of the board shall be such as may be specified in the bylaws, but shall not be less than 50% of the total number of the directors of the board. This bylaw also says the same thing, lordship, without referring to the maximum number. All it focuses on 50%.
Which bylaw?
Bylaws, this.
Which one? Bylaw? Provision?
Bylaws, section 26(3). 26(3). There is no conflict between these two provisions, lordship. Because neither refers to the number of maximum directors. It refers to a ratio, percentage. The bylaw says, lordship got it, 26(3). The requisite quorum of the board shall be 50% of the total number of members or 8 members, whichever is the maximum.
Yes.
Without specifying any number, what is the maximum number of directors? But here it says talks about 8 bylaws without specifying the numbers. There it's totally silent about numbers. Both the provisions, what has changed is, lordship, now maximum has gone up to 21. Otherwise, that quorum may presume to be the same, that 50%. Bylaw says 8, yes, only 50%.
Yes. And what are the other two repetitions?
And the writ petition will depend on this, my lord, on this disposal of this writ petition.
Okay, but
Yes, ma'am. Whatever the decision
what
comes,
is,
my lord. it
what
will
is
get it
this
to you.
second repetition?
Yes, second writ petition, your lordship,
One minute. Board of Directors. Behera.
second writ petition after having obtained the stay order, my lord. Then respondents register has filed an appeal before the division bench. That division bench again, my lord, send the matter.
What?
After having obtained the interim order in the writ petition, my lord.
In this petition?
Yes, my lord.
Yes. With the
after-
interim order?
Yeah, interim order, my lord, that state, the interim order was stayed, my lord.
32. Stayed, yes.
Yes. Writ appeal was filed.
Writ appeal was filed.
Yeah, against the stay order.
Oh, Mr. Taludar, you have preferred. You preferred.
Yes. Yes, yes, writ appeal.
Okay.
Yes, yes.
Mr. S.K. Taludar,
My lord.
writ appeal was dismissed. Okay, thereafter?
Thereafter, my lord, the writ petition, my lord, continues to be heard.
Yes. Allowed.
Then, my lord, the committee, managing committee was dissolved by the registrar.
Being
Sorry,
aggrieved.
by the junior joint registrar, my lord. You not will find impugned order at page 16.
এখন আপোনাৰ আছিল নেকি? এখন আপোনাৰ আছিল নেকি? আপুনি দিছে নেকি এতিয়া? আপুনি লিখন দিছে ন? আপোনাৰ এখন মোৰ কপি এটা আছে ইয়াতে।
That is a different matter.
Yes, ma'am, different matter.
We
Different
will
matter.
hear it then.
Yes, ma'am.
Because he was asked to produce all the original records.
Yes, ma'am.
While passing the interim order until further order.
And subsequently,
No affidavit is filed.
no affidavit is filed. Then subsequently, in the second impugned order was passed at page 57.
Huh?
At page 57, the impugned order passed by the, my lord, junior joint registrar, my lord, dissolving the committee.
But that is different matter.
Yeah, different matter.
That is under stay.
Yes, understand.
Little like that.
Yes, ma'am, it will depend on this, my lord. So that first it may be disposed of independently, ma'am.
Yes. And what is this contempt? It arises
The
out of
contempt
what?
is that they have violated the stay order, stay order passed by this honorable in the first writ petition. Because dissolved the committee, they have been restrained from doing so.
That is in the second repetition.
Yes, second writ petition. Yes, my lord. Second writ-
Contempt is out of the second.
Yeah, out of second writ petition.
Okay, we'll leave it.
Yes, my lord.
That is a different issue.
Yes, ma'am.
Okay. 925 will go. Heard. B. Sinha. Learned Counsel for the petitioner. S.K. Taludar, Learned Standing Counsel Corporation Department.
60. 6.
Petitioners, huh? For the respondent number 1, 2, and 3, and Mr. R. Goswami. Learned Counsel for the respondent number 4. Arguments are heard, judgment is reserved. In the other petitions, এটা একেলগে কৰি দিব 2417/2022 contempt case number 701/2023. Yes, Mr. Talukdar, produce the records,
Yes.
whatever is asked.
After-
Mr. B. Sinha, learned counsel for the petitioner, and Mr. S.K. Talukdar, learned standing counsel, Cooperation Department. For the respond number 1 to 4. Full stop. Notice not issued.
Not issued, madam. Contempt was just but attached with the writ petition.
Huh?
Contempt petition was attached with the writ petition.
No,
Notice
no,
not
in the writ petition, it said notice is not issued.
No, writ petition
And
stay order was
nobody,
passed.
no, huh?
In the writ petition, stay was passed, madam.
Stay was passed.
Also, that's
No
my of
notice.
course.
No
Oh,
notice.
Also, my lord, does
oh,
not
I have
come-
not also, my lord.
Stay also
Sorry.
not extended. Till this.
Stay is extended. You stay there.
But while passing the order, while passing the order, because after 2-3 dates, from the second date onwards, in the second writ petition, both the writ petitions are tagged,
Oh, yes, notice.
right?
Yes, notice was not issued.
And
Interim order was passed in the first case, madam.
right, no, that is also.
No, second.
But question is, Mr. Talukdar, interpretation of the first order itself.
Yeah.
Until further orders of this court.
That will, my lord, in that first case, it will.
No, second case.
Oh, second. It will go.
Without issuing notice,
That cannot, my lord.
it is you who are party to it. Then you preferred appeal. That was also dismissed.
No, dismissed not on merit. Dismissed on
Whatever.
a different ground, my lord. Pendency of the
But it is
litigation.
there until further orders. That is why it is not extended from time to time.
Well, that will be followed.
But I am still checking
Well,
whether
yes.
I am issuing notice for a second time again. Mr. Sinha, you could have told the court.
Yes, sorry, my lord, I also, my lord.
Talukdar also.
Yes, I have also missed this point, my lord.
Extra copies were also served to you in the second case.
My lord, in fact, I will, my lord, place the records. Lordship will make a, my lord, specific.
Heard
observation.
Mr. B. Sinha, learned
145
counsel for the
amendment.
Yes, yes,
petitioner,
I'll do.
and Mr. S.K. Talukdar, learned standing counsel, Cooperation Department for the respond number 1, 2, 3, 4. Full stop. Issue notice returnable in 4 weeks. Extra copy it is submitted that extra copies of the writ petition has already been served. Have already been served upon the learned standing counsel, Cooperation Department in terms of the order dated 1/4/2022. Full stop. Yes, whether these 2 persons are required to be.
No, they may be struck up.
Mr. Sinha, learned counsel for the petitioners has submitted that the names of the party respond number 4 and party respond, 5
5 and
and
6.
party respond number 6 can be deleted as they are not neither necessary party nor proper
Yes,
parties.
yes, ma'am.
First, in view of the above submission made by Mr. Sinha, learned counsel for the petitioners, the names of the party respondent number 5 and the party respondent number 6 stand deleted at the risk and cost of the petitioners. Full stop. Mr. Senior, learned counsel for the petitioners have filed an amended
Yes,
cost
yes.
title in terms of the notification dated so and so within 3 working days from today.
Yes.
Mr. Talukdar,
The copy of the amended.
Yes.
Mr.
Yes.
Talukdar shall make endeavor to produce the concerned records in terms of the order dated 1/4/2022 on the next date of listing. First up. The interim order passed on 1/4/2022 stands reiterated. Yes, so yes, Mr. Deka. Then we'll pick up for further consideration on another date. Mr. Sutia, you take note of this, and Mr. Sen, you take note of this, then I'll go through. I'll go through it. When? Not Thursday. Someday else. Tuesday?
Tuesday next. Milord.
এটা লিখে দিব BK Sen, J. Sutia, Standing Council KAC, D. Deka, Standing Council, some Information Commission. Present as sought for by Learned Council Board of Parties is the case on Tuesday, 12 figure.
My name is not reflected in the.
The name of Mr. D. Deka, Learned Standing Council, Assam Information Commission.
State Information Commission, Assam, or Assam Information Commission.
Assam Information Commission be reflected in the respondents in the call list.
Highly obliged.
Obliged.
Item number 23 to 30.
Yes, what are the matters?
Here the eviction notices has been challenged, my lord. Item number 23, 27, and 28 are identical. Where there is no other litigation pending or there is a previous history of any litigation between the parties. We have simply challenged the impugn notice of eviction being bad in law. And my lord,
23?
item 23, 27, and 28, my lord.
Okay, your cases.
Yes, my lord.
Hmm.
No, this is a different.
Yes.
What do you have to say? You can say.
Hmm. We can only start, cannot end.
Well,
I have to,
some instructions in this matter have been furnished. Yesterday, I could not go through it, Malad. I have received it yesterday only. Maybe fix on another day so that I can go through and I can make my submissions. Malad.
And furthermore, your lordship, affidavit has been filed only in item number 23. Affidavit in opposition by the state, whereas
23.
yes, my lord.
Hmm.
So for the rest of the cases, I cannot say, my learned friend.
Yes, no affidavit.
Actually, my case is item number 38, the last case. In this case, my lord, there is an order of your lordship, my lord, May 2023, where it was said the government would file affidavit in my case because there are some contentions are there. I also furnished copies also of the lead petition. But
30.
yes, my lord, last case. So that if they want to file an affidavit, it will be better, I think.
Your case is same or different?
My case is different, bit different.
Then why it is tagged?
Actually, they relate to my lord, almost the same property, same land.
All numbers are same.
They made a prayer for my lord filing affidavit.
Then Mr. Nath, you find out, check out all the case where you intend to file, you file within a specified time period. And wherever you do not want to file that you will like to rely on a comprehensive affidavit filed somewhere, you make a mention. I think that will expedite the issue.
We can proceed accordingly.
23 to 30, right? Then write the names of the council in a piece of paper.
Yes.
In item number 25, National Boards Limited was impleted by order dated 9/9/24 in IA Civil number 776. And the impleted party has not filed the amended cause title as of now.
Who are they?
No, my lord, actually, I filed
National-
an impleading application to be impleted as respond number 8.
Eight.
And I was impleted. So cost title, the writ petition was filed by them. So I think they should implement it.
But Lordship, as per the notification dated 9/6/24, the party seeking the amendment of the cause title shall be required to furnish the.
There is
amended
a
cause title.
notification. There is a warning in a notification and it is you.
I'll go through it. I'll do it then.
নাম কেইটা লিখি লব পাৰ্টিবোৰৰ কোনটো পিটিশন কোন আছে জি জালান petitioners in 23 learned council লিখিব petitioners in 23 27 28
Lordship,
M
if I may-
Kotoki 30 why criminal petition
That is, that criminal petition is attached with that their writ petition.
your name is item 24 petitioner name
Ananda Namasudra, no? Not 25, no? তোমার একটা criminal petition আছে না?
give the names
24, my lord, we are newly engaged, Lordship. In 24,
give the names
Lordship,
Clearly.
in
And
26
Mr.
and
D. Nath.
29,
Mr. D. Nath, learned senior government advocate for the state, Assam, for the state respondents. Yes, Mr. You were there. For whom?
Because of this criminal petition,
And Mr. K. Parahar, learned additional public prosecutor. Are present. First of Mr. D. Nath, Mr. Nath, learned senior government advocate, has submitted that it is found that except in item writ petition number 23, item number 23, the state respondents have not filed any counter affidavit. First of Mr. Nath, learned senior government advocate, has submitted that depending on the issues involved in the writ petition, the state respondents will file counter affidavits in the writ petitions. Either a comprehensive counter affidavit in all these writ petitions or separate counter affidavits as required or as required, on the basis of the issues involved in the writ petitions. He has sought for 4 weeks, 4 weeks time to file such affidavits. File such comprehensive affidavit stroke or affidavits. First of Mr. Kotoki, learned counsel for the newly implemented respondent in 25 shall file an amended cost title in terms of the notification number 73 within 7 days from today. And the cost title has to shall be corrected accordingly. First of anything else?
Lordship, my lord, in item number 25, we are newly engaged advocate.
If you have file color number, it will be reflected.
Respondent has died, Lord, my lord.
Mr.
D. Gogoi.
D. Gogoi, learned counsel, has submitted that and color number has been submitted in item number
25, 24.
24 and 25.
Lordship, in 24 for the petitioner, in 25 for the respondent, my lord. Out of my lord, four.
In 24 and 25.
My lord, two respondents.
So the office to trace out the same. Office to reflect the names of the councils on the basis of such okaradamas, stated to have been filed. Lays the cases after 4 weeks.
number 10 for order.
May I please, Your Lordship? Lordship, as per order dated 3/10/2024, this honorable court has directed the concerned jurisdictional executive engineer for making an assessment of the damage, but nothing has happened till date, Lordship, and to submit the report with regard to that.
Lordship, if I may, Lordship, here I'm appearing on behalf of Mr. B. Google, Lordship, here, although PWD was not made a party, Lordship, here we were directed to share the same, Lordship, as per my instructions, we have inadvertently missed out on the matter today, Lordship. Lordship may post it next week, we'll intimate the same today itself to the authority concerned and produce a status report by next week, my lords.
Mr. S.V. Chaudhary, learned counsel for the petitioner is present. Mr. A. Choliha, learned counsel appearing for Mr. B. Gugoi, learned standing counsel PWD, has submitted that inadvertently, this matter listed in the cause list could not be noticed, escaped their notice, and as such has prayed for.
Lordship, the assessment has not been made as per the instruction that I have received.
Has prayed for a listing of the case on another date to enable him to obtain, to place a status report. Full stop. In view of the reason cited, the praise accepted, lays the case on 25.
Lordship.
25.
Lordship, in the meantime, the assessment is to be made
Yes,
because
Lordship,
till date it has not been done.
Yes, Lordship, we'll inform Lordship from this report, Lordship.
Item number 11.
Your piece, please. Mr. Dina.
I have received some instructions from the chief engineer and the department also, Lord. As per the instruction, Lord, the proposal has been sent by the executive engineer and to the chief engineer. Now the chief engineer has also sent it to the department. For approval, Lord.
Mr. Dinath, learned senior government advocate, has submitted that the demand proposal seeking fund amounting to rupees 11 lakh 41,666 has been sent by the chief engineer PWD Rose Assam to the PWR department, Government of Assam, on 24/10/2024, and outcome is awaited. Also, lays the case on 26/11.
I'm agreeing for response number 3.
लिखी दी वो so and so for the response number 8 K Pukan R Dhor. The legible learned counsel for the petition is found absent today on call. Huh? Yes, Mr. Mozumdar, you are waiting for what? But I cannot delay also. There is some Official engagement.
Hearing matter.
First hearing matter. Bijari Vinir.
Because of the earlier orders passed, my husband was also present. We cannot leave the court. Possibly petitioner was absent for a couple of days. Then the,
Not couple of days, on last occasion only.
some order was passed. But then today he's present. If he is found to be absent only in the event, they possibly the court directed that some order will be passed.
Okay. Mr. R. Hussain. Learned Counsel for the petitioner. Mr. D. Mazumdar, Learned Additional Advocate General. And you, Mr. J. Sutia. Learned Standing Counsel. KAAC. I are present. First of due to paucity of time, the matter could not be taken up today. Many matters are fixed now. This is 3rd of December then.
Yes.